Hey, Young Jurks, I saw you all gathering, all waiting for the last 24 hours. I think there's already 1,000 you in the chat. Welcome. We got a big show tonight. This is going to be an epic moment here. Special night. I don't even have much to say. I don't even know what we're going to discuss tonight. Let's just get to the guest. That's what you're here for. Let's bring up Mazza Media first, and then we'll bring up what everybody's waiting for to hear from attorney Mark Bederow. Mazza Media, welcome back to the Young Jurks tonight. 3Ms. What do you think about what's going to happen tonight?
It's going to be a great show tonight. I've been fired up for it since yesterday. I'm all ready to go. I'm ready to rock and roll, and it's going to be big. Mark Bederow is back. He's going to start being on appears on streams again. The 3Ms has basically been renewed for a second season, and the energy online right now has been unmatched by anything we've seen. It's just this is a big time moment. As Joe Flipperhead likes to call him, the bunk. The bunk is back. The bat signal, the Bederow signal, has been firing up in the skies over New York City. And we got Mark Bederow ready to rock and roll with us. And the only thing we need is we need another Celtics championship to go with this, just like last year. We need the 3Ms, another Celtics championship, but a different ending to the Karen Read case this time, which is Karen Read being acquitted of all 3 charges in 2025.
I also felt like we needed attorney Bederow in court for Karen Read.
Yeah.
Unfortunately, that's not happening, but we did get something great that came out of this. He's back on the show. I mean, that is one of the best things is that we're going to get to see and hear from him tonight. I'm just looking forward to what he says tonight. Just sit back and just watch Bederow do his thing tonight. People are lining up. It's like, it reminds me of like Star Wars 1977 when people are lining up on the street, sleeping out in tents. People are amped up for this. So let's bring them up. This is it. This is the special moment. Attorney Mark Bederow, refused by Judge Bev, but never refused here on the show or with the speech or with the followers and the fans and the attorney Bederow. How you doing?
I'm okay. The Star Wars thing's a little bit over the top, but
you're being modest. You're being modest.
Hey, thank you for the kind words. Nice to see you guys again. Long time.
Yeah, exactly.
Yeah. It feels good. It feels like family coming back together. It really does. It's like, wow, we're going to get to do this again tonight. This is wild.
Well, it's been a pretty weird couple of weeks.
Yes. To say the least, yes. That is
don't take it personal, but this is not what we wanted or expected. But it's
right.
Yeah, I mean, ultimately, I'm still mad about it. I don't know how mad you are, but I'm mad. I got really mad about this when it came down. I wanted to see you defending Karen Read. I'm wondering what you want to say about it tonight. I mean, do you want to even address what do you want to talk about tonight?
Whatever you guys want within reason. I mean, there are things obviously I cannot and will not say. So there are some guardrails that have to be in place. But in terms of being mad, I would say more disappointed than mad. I think any lawyer who does this for a living at a high level wants to be involved in a very high profile, serious case, certainly one in which you think the client defendant is being railroaded or is being over persecuted rather than prosecuted. So you're going to want to be in that. And also, as you know, a lawyer at a certain level, you always want the opportunity to work with lawyers at a very high level. And as you know, there are 4 other lawyers on the case who operate at a very high level. So just lawyer to lawyer, that's always an attraction too, to kind of collaborate and work with such skilled lawyers pulling in the same direction, believing in a cause for justice. So yeah, that's disappointing. But listen, you know, I don't practice there, so I don't make the rules. We can talk more about other thoughts about it, but I would say more disappointing than mad.
Excellent. Maz, do you want to say anything about it?
Yeah, I mean, they kind of said that Karen Read's defense team already has several attorneys that are, you know, essentially from out of state. You know, Elizabeth Little, Liza Little, Alan Jackson, among them. I don't know if you can answer this or not. You can always just, you know, refuse to if you need to. I don't know what your limitations are, but Was that an acceptable reason to you, if you were able to answer that question, or pass on it if you must?
No, I don't think that's an acceptable reason. I would suggest, if you saw how this case has proceeded from the get-go to where it is today, is it any surprise that a client fighting for her life would want several attorneys who are not part of the Massachusetts or Norfolk County system? I would suggest it makes perfect sense that you might want some big city lawyers to join, obviously very competent and able local counsel who come from very strong, high-powered legal markets, ex-prosecutors, experienced criminal defense attorneys. Given what you're dealing with and everything that you see that goes on in Norfolk County, it's no surprise at all. I mean, don't forget, you're also dealing with a case where even they have to bring in other prosecutors, apparently, admitted locally, of course. But, you know, everything about the Karen Reed case is weird and off. So the fact that somebody wants an extra lawyer who is skilled at that level to do it, is willing to do it, of course it should be permissible. As far as this issue over alleged conflicts, there are rules in place in every state for dealing with possible conflicts of interest. There is a way that you address those with clients and prospective clients, and those I's are dotted, those T's are crossed. It was spelled out in an affidavit that was submitted. And if you saw, I extended the offer to speak ex parte to the judge to explain any concerns or any possible issues which any judge might be concerned about the joint representation in this case. I mean, admittedly, it's a unique situation with two clients that have some degree of overlap, but any possible conflicts that are waived in that manner and are knowing and voluntary waivers that are not actual conflicts and that are deduced to writing, that should be sufficient to allow the client to have counsel of their choice. So do I agree with the ruling? No. Is there anything that I personally can do about it? No. Do I think it was correct? No. Do I think adding language saying, well, she already has 4 lawyers, 3 who are from out of state, is an appropriate consideration? No, that's my view, but I'm not the judge. So what am I going to do other than, I mean, you're not going to get rid of me in Norfolk County. I've got another little small case you might have heard of that I have to come back and will gladly, zealously advocate for, and will continue to do so. So I'll be back. It's just not going to be in the capacity as Karen's attorney. That's all.
Presenting Aiden Carney, Turtle Boy, in court. It's funny because we get this comment tonight. They love your sweatshirt, love Mark's sweatshirt from Melissa. There was a poll about what sweatshirt you'd win. The poll said that it would most likely be the Celtics, followed by Arizona State. Third place was the Patriots, I think, and then the Red Sox. But you threw it out a wild card. You got the Kowloon on tonight.
I have the Kowloon on. There's all other kinds of ones that could be thrown in there too. Patriots, no chance. Off season, what they are right now, that would never be a consideration. If I were betting, I would have bet on the Celtics, but here we are. So wild card. No, I didn't see that. That is kind of funny though.
Yeah.
Kowloon. Yeah, we got to meet up at the Kowloon again. That's good. Definitely going to happen too eventually, and we love the Kowloon. If the Kowloon's watching, they better like comp a drink next time we're there or something. Drink.
Send us some wings and some tangerine beef, please.
It'll be good to go.
I used to deliver beer there, and they were very good to the workers. Like when we deliver beer, they give you the free lunch. So I love Kowloon. They hook up the workers. So yeah, it's good to know. When they treat the little people well, they're going to treat their customers well too, right?
Right.
They definitely do there. Love it. Yeah. So there's been so much happening in the Karen Reed retrial, especially with all these motions. Have you been I'm sure you've been keeping up with all the motions. What are some of the big ones that you think people should be looking at or focusing on, or even wondering what the judge is doing?
Well, I mean, there are so many flying around that it's hard to even keep track of all of them. Let me also just say real quick, I mentioned guardrails. So what I'll discuss are things that are in the public record. Okay. So one thing I would never do or share any internal thoughts or conversations with other people or things that are not public. So that is the guardrail. Publicly filed motions are publicly filed. I'm not participating in this litigation, and I'm certainly not someone who, quote unquote, has appeared in this matter. They made sure that was not going to be the case. So there's no issue in discussing that. But as far as all of these motions that are going back and forth, you can probably imagine, while there's one that I might have a very keen interest in and find fascinating about, people that are added to the witness list. And I know that there has been a promised motion, as I understand it, potential motion in limine coming about that. That's perhaps a conversation, again, within the proper guardrails. But that to me is the most interesting one for obvious reasons, just because it affects me.
Can you talk about that one? I don't. Which one you're talking about? Aiden Carney being a witness.
They've put him on the prosecution witness list. That's public. That's been reported in the news. The idea that a prosecutor would call him as a witness in that case is highly unusual, to the point of never heard of anything like that. In fact, you might have even heard some public discussion at a recent hearing where there was incredulous approach by the judge asking the defense, "You're really going to call these witnesses that you never spoke to?" I would think that this would be even a trickier conversation. And, look, we're going to have to address this, and we'll have to do it publicly. But, do many people believe that this is a stunt, for lack of a better term, to deprive a journalist from covering a case and excluding them from the courtroom and those sort of things? Yeah, I think a lot of people believe that. And I think there's been a pattern of that's been occurring based on numerous public filings and legal proceedings and arrests and things of that nature that you've seen over the last 2 years. So that will have to be dealt with in due course. But yeah, to me, that's certainly the most interesting one.
Matt, you get any follow-up on that one?
Well, I wanted to kind of branch out a little bit. I know one of the things you said on X recently, Mark, after the determination by the judge that you have no history of bad ethics as an attorney, and that you were able to represent one client, whether that be Aiden Carney, or represent another client, whether that be Karen Reed, while being upstanding about that and making sure you're maintaining a level of everyone keeps saying my microphone's low. Maintaining a level of professionalism and staying within the regulations of what you need to do and what you need to say to represent both of them. Do you see any reason why a judge would, if you're able to answer this, I understand, or not, I understand. Is there any reason why a judge would have a reasonable concern, regardless of who you are and whether or not that judge was corrupt or biased or whatever? Do you see any reason why this would be a justifiable, in a generalized case, it would be a justifiable move to maybe take? I'm going to exit the show in just a second, Mike, because everyone's complaining about my audio.
I just think I just turned it up. I think
okay.
You're probably a little better now. If I need to turn it up more, I can turn it up. Keep going.
Okay, perfect. Mark, did you get that question, or should I rephrase it? I got a little distracted. I apologize.
So it's kind of a long answer. The first thing is, so I started practicing law in 1998, was admitted to practice and formally after passing the bar in 1999. I am admitted in 2 states, 2 federal courts, and have never had so much as a whiff of an ethical issue that's ever been lodged or successfully argued against me or whatnot. So obviously that would be a basis to potentially decline somebody pro hoc vice if they have some ethical baggage. I think most people would understand that that's a reason to decline them. If there are issues over concluding that there is a conflict, that's problematic, because you would expect the lawyer to be given an opportunity to be heard ex parte with the judge. In fact, the prosecutor, if you recall, suggested that he would have no problem with that, which is a proper consideration, which leads to the next point, which is that the prosecution never objected. They had a, what I'll call a non-objection objection. You can assess whether that was proper or not, but there was not a formal objection. There was just kind of a whiny complaint that contained a lot of smearing and allegations that, as is a pattern, again, all of this is in the public record, but that there is a pattern in that case of the prosecution in the last several months of not submitting motion responses, not submitting sworn affidavits in response, not providing notice of their intent to argue, and then making all kinds of unsworn or unsupported statements in court, which turn out not to be true. And I can tell you that if some of those things that were said about me in court were said on the street, then one could argue if those are actionable, okay? Because there were some smears and comments that were made suggesting that I had leaked information or provided information or was sharing information or was involved to be a vessel between two clients. That is 100% patently false, unadulterated bullshit, okay? That never happened, was never going to be happen. And for this guy, Brennan, to say that so callously, so loosely, and so easily, that's on him, not me, okay? To suggest that we filed a motion similar to the motion that he was complaining about in the Reed case and said, I'll bet you they're going to seek sanctions against them, true, that is patently false. That is also 100% unadulterated bullshit. We redacted everything that wasn't in the public record. And he either knew that or he should have known that. And he has a record, okay, of making very fast and loose statements, including, accusing people of making statements that were not in court because he said they were on court TV. And it turns out they absolutely were in court. But look, this is neither here nor there, okay? He made a non-objection objection. The judge, without hearing from me, found it permissible to do it that way, made comments that there were already 4 lawyers, 3 of whom were from out of state. So in her mind, that was enough for the defense. It's not my place to say anything beyond that, other than what Brennan said is absolutely outrageous, reckless, and not true. And he's lucky he said it with what we call a litigation privilege, because that is bullshit.
Yeah. Well said. Well said, because that's exactly how we all feel. We're all frustrated about this, and we don't appreciate it. And again, you have a great record. You have no history of any ethic issues at all. You've been an outstanding attorney historically throughout your entire career, practicing in New York. And it just seems to me like everything, this particular judge or this particular prosecutor have found a way to get you out of there as soon as possible, in my estimation, because I think you're an absolute threat, because you're a big-time attorney. You know a lot about this case already. You're not coming into this with no education on this matter. You're very well educated to this whole situation. And I really think they're very intimidated by you and very scared, quite honestly. And they know when you come in and join, had you come on and join that particular team, it would have been a bigger fight for them than, it's not taking anything away from the attorneys that are already there, but it's like anything. If you have a great sports team and you add another great player like a Corey Dillon or a Randy Moss or somebody like that to the team, it only makes that team even more powerful. And I think they were absolutely threatened by you. You don't have to comment on that, of course, no pressure there, but I think they were absolutely threatened by you because they knew you were going to pack a lot and add a lot to that particular defense team.
I think it would have helped for sure. I mean, look, I appreciate those are nice words. So I do appreciate that. The bottom line is this. They're going to be fine, okay? There are 4 top-level attorneys who all do various things that bring this together. To use a Celtics analogy, I would have seen my role as maybe like the Derek White of this group, okay? To come in and just lend a hand and be a solid glue guy, all right? Late to the party, turns out too late, as it were. But that would have been, in my view, the way it would have played out. But they're going to be fine. I don't think the result, frankly, is going to change one way or the other. I mean, you never assume that. So you want as much legal firepower as you can get. But being an outsider still to this whole process, I just don't see the result being anything other than not guilty, with or without my involvement.
Right. Yeah.
We have a lot of super chats coming in. I want to ask some of those questions, but I want to ask about this first. You had made this post, a PR 101. It's about the Proctor family making the statement about Michael Proctor the other day. What do you want to say something about this? Because I know you've made a lot of comments on this show about Michael Proctor. What do you think about this whole thing?
Look, if you've done a lot of high profile cases that get media coverage and whatnot, you learn about PR and how they're covered and just how public relations works. It's pretty obvious that Michael Proctor and his family have no freaking clue how PR works or should work, because what he did the other day was an unmitigated disaster. And so start with like the effect of it and then go back and explain why it's so ridiculous. Do you think that there is a single person on the planet Earth, literally one, who a couple of days ago had a more negative view about Michael Proctor than they do today? Do you think they literally tilted the needle to one person to say, now I feel bad for him, God, he's getting screwed, and Karen Reed must be guilty? No, the people who are defending him were defending him anyway and are basically family, and certain people on Twitter or whatever. And the people who think he did terrible things or is not credible feel the same way. But all they did, the people in the middle or who may not know about it, they've drawn attention to it. And so the net effect is a net loss at best. But then you talk about just how they did this. If he was going to make a statement and literally seek to restore himself, he needed to do it himself. Okay. He needed to get up and issue a statement. And if he even had more courage, do it in front of a microphone so people could see him and hear him, and a contrite voice, and do it. But backtrack for a second. He couldn't even do that at the first trial. Okay. I'm sure we said this when we talked a year ago. One of the most things is that if the DA was going to call him, that they wouldn't tell someone like Proctor to take your medicine like a big boy. And if you're still nervous, take another shot just to make sure, and look at Karen Reed in the eye in front of all these people with the cameras rolling and say, I'm sorry for doing that. You don't have to apologize for arresting her if your position is she's guilty. That's a different issue. But I'm sorry for that. It was wrong. I shouldn't have done that. I sincerely apologize. He didn't do it then. He didn't do it now. So but even worse, the people that he uses as his fullbacks to try to clear the hole for him to get through are his wife and sister, which on one hand you understand because they're close to him, but these two people are embroiled in part of the very problem that accentuates the Proctor problem, because they're involved in the so-called gift offering and receiving, which is part of everything that's wrong with him. So those really aren't the two best people, I think, to do that. Then if you're going to promote this, there's probably somebody better than this John DePietro character who I had never heard of in my life until this case, but simple Google search tells you that he's got some issues with fake pump numbers and whatnot. And he's also the guy who the week before went on court TV as an expert and was talking about what a powerful and devastating witness Fanning was, who of course didn't testify at the first trial. And the hostess on court TV is nodding, yeah, what a powerful witness. So you can see just what a complete fiasco this is. Last point is when they get this DiPietro, whatever his name is, guy, and it's interesting because he's kind of a confrontational journalist, which maybe sounds like somebody else who they charge with witness intimidation.
Sure.
Want to be Turtle Boy. Yeah.
Putting that aside, he says this is going to be Proctor's revenge. And that's how you really know that this is just amateur hour and you should cue up the clown car music, because you have to be contrite, and there's bitterness, there's nastiness. Put that all together, and what do you get? You get a terrible rollout. Yeah, you got some media outlets to pick it up, but because it's interesting, but it's like a non-statement statement. Within 24 hours, is anybody talking about the rehabilitation of Michael Proctor or how the needle has changed in his PR? The answer is no. And this is a one-shot thing. Again, if you understand PR, you don't like get a mulligan and say, let me try again, and it come off as sincere. That moment passed. It passed at the trial a year ago. It passed this week. And at this point, you're stuck with him. They didn't even address the allegations against him. And again, the allegations against him are actually 1,000 times worse than they were a few weeks ago, because what you saw in the public record, this is all public in court. Apparently, he's going to be the patsy to explain the video, right? He's going to be the guy who just found, ate, and swallowed the video and forgot to tell everyone. So they're going to have to explain that. But in the meantime, he wants this apology through his proxies, which are his family, who were involved in, discussions about receiving gifts. That's what you call a PR fail.
I'm laughing so hard about the DiPietro guy who that Fanning testified, and the woman on court TV said, "Oh yeah."
But that's the thing, like credibility. Hilarious. If you're gonna use that guy as your microphone to advance all these issues, and he's very sincere about his knowledge of the case, it helps to not have him up there on court TV, almost like getting himself to the point of hysteria. He's so excited about this devastating witness who never was. I mean, it's like the man who never was is who he's talking about. And the host just is nodding and nodding. And let's be honest, it makes court TV just look like a complete joke.
Oh, they are. Yeah. They've had some interesting guests on that show from time to time. That's for sure over there on Court TV. Of course, Julie Grant's everybody's favorite over on Court TV, and just her wonderful take on the whole entire Karen Reed movement.
I believe she was the one who was hosting that piece.
Of course she was. She was. Who else would invite DiPietro on? Oh, of course. That's so funny.
Anyway, that's my thoughts about the attempt to rehabilitate Michael Proctor through changing the narrative with the press release. I thought it was comically not well done. Let's just leave it at that.
Yeah, all it did is got all the YouTubers and everybody else talking about Michael Proctor some more.
Right.
I mean, not very helpful to them.
No.
Yeah, but Mazza, do you want to add anything else?
No, I just thought it was an interesting time. Yeah, well, just interesting timing on when the Proctor family decided they wanted to make some public comments. This is something they had never done before, and then all of a sudden, the timing on that seemed to be very much unique, in my particular opinion.
I mean, look, without even getting too much into them, and we've probably beat this to death, and the horse is twitching, and we should stop kicking, kind of thing.
Right,
but. One of the women involved in this statement was involved in conversations about like wishing death upon Karen Reed. Again, probably not a great spokesperson for purported contrition. And it's just, boys being boys on their cell phone being stupid. Actually, it's not. The people making the statement were having those discussions as well. They were involved in other things, including making statements previously. One of them, it's been reported, was making phone calls, trying to get people terminated from their employment. So they have done things. This was such amateur hour PR. I mean, if they were really going to do this, they should have hired a professional, and any professional would have told Proctor, if you can't put your big boy pants on and get up and be a man and speak from the heart, then this is just a bad idea.
Right. That's what you need to do. You need to speak from the heart.
Yeah.
Do a video. Dude, come on this show or our show like it, or even Kevin's show and do that, like somewhere.
I mean, I'm not even.
It's too late. It's too late now.
No, it's over. I mean, they screwed the pooch on that one. So just now at this time.
Yeah, he should have done it in court, like you said. There's a gag order too, isn't there? Isn't the gag order in effect now? And
the gag order applies to lawyers who have appeared on the case. So Michael Proctor and his family are not literally subject to the gag order. Now, if the district attorney had input on that, that would be problematic. I'm not suggesting they did, by the way. In fact, I would suggest to you that the district attorney is probably banging their head saying how freaking stupid this was to draw attention to him a week after we just basically threw him under the bus and claimed with a straight face that nobody in the DA's office for 2 years had any idea that there was any video from the Canton Police Department. Now, whether that's true or not, the bottom line is their position is that Michael Proctor just found the video, chose not to tell anyone. I mean, that's impossible to believe unless you think there's something nefarious going on. So given that's who you have to bring to the dance, that's their guy, I don't think they would want him making these amateur, foolish statements. So, but in a literal sense, no, Michael Proctor is not subject to the gag order. The gag order relates to lawyers who have appeared on the case. If I appeared on the case, I wouldn't be talking to you right now.
So you have no gag order, and Proctor has none. That's good to know. I thought that witnesses did, but they don't. It just
no. There are things that I would, for reasons not discuss, obviously, if they're not public. But in terms of a gag order, no. I never even got so far as to appear on the case.
Right.
A question for you and. Oh, go ahead. You want to?
Yeah. So the attorneys on the case right now, Alessi and company and Jackson and all them, they can't talk to anybody about this at all. So once you were out of the loop and you were denied, there's no way you can advise them on the side. You're totally, because of that gag order, they're totally shut off from everybody. Is that an accurate?
Well, a gag order means like public statements. I mean, it doesn't include,
right.
I mean, if I were to talk to lawyers who represent Karen Reed, I mean, none of us are going to turn into pumpkins because some magic thing. But no, they are precluded from making public statements that would, reasonably be believed to be disseminated in a public forum, which could somehow influence a jury or whatever. I am not, because I never appeared on the case. Michael Proctor is not, because he's not a lawyer. If Jennifer McCabe wants to scream and yell publicly, she can, if that's what you may not like it, but she has a right to do it.
Right.
Means the district attorney Morrissey can't do another video, right?
No, I mean, I'm sure we talked about this last year too. My recollection was when we went over the hostage video, that thing probably violated 11 sections of Rule 3.6 about things that you're just not allowed to do. And look, it had to be a hostage video. I mean, I don't know why any prosecutor would ever make such a foolish and just, in hindsight, factually absurd statement unless he was, asked to do that. But,
maybe a couple too many drinks or something. I don't know. I couldn't figure that one.
I don't know. It was just, and we probably talked about this too. Yes, it's true. Wendy Murphy was the original. What are we doing here? This is interesting. But what little I knew about this case before and followed, I was more interested in some of the legal stuff that was going on in the background. And I do remember very distinctly sometime in the summer of 23 reading about Morrissey making this statement and saying, what is going on in this area of Massachusetts where a DA thinks it's permissible to just start ranting and raving about, how honorable the witnesses are, how guilty the defendant is, how, again, you could go through Rule 3.6 and check off every box of don't say this, he said it, don't say this, he said it. And it was my first introduction to, just Norfolk County is different, to say the least.
Different, very different. And they don't know the witnesses. Michael Proctor doesn't know any of the witnesses. He didn't know, he's not related to them. Jen McCabe doesn't know any. It's all this crazy stuff.
Well, it raises all kinds of issues, which is, why would he say that? I mean, he's not making that up out of whole cloth. Somebody's telling him that. So the real question was, who's lying, right? Who's saying, what was it, Proctor himself? Was it, someone else from the state police? Is it the prosecutor at the time, who is now, I don't know what you call him at the time. He's still there, I guess. I don't know. But either way, this is just totally ridiculous.
The question of, they want to know, Mark, do you have any thoughts about the closed federal investigation, allegedly closed? Because we, look who it's coming from. Joanne is asking, could charges still come?
Sorry, I see what was put up for this. I'm not touching that. Sorry, guys.
Okay, fair enough.
I can't. I apologize to Joanne, but I that's part of the guardrail system here. I'm not getting into that. I can't.
Crash Miami says, glad you're back, Attorney Bederow. Can the defense do anything about Brennan constantly lying since Judge Bev won't?
Well, I think as you've seen in statements in open court and in some of the court filings, I think they're doing a pretty damn good job of exposing what they are and letting the judge and world know and defending themselves to that. What else can they do? Yeah, there are other potential things maybe after the trial. But again, I think they're doing a pretty solid job in making it clear that there are a lot of alarming amount, frankly, of just seemingly inexcusably inaccurate statements being made, as well as, as it relates to me personally, just in that little minor hearing, lobbing all kinds of accusations without making formal accusations, without putting them in writing, without putting them under oath, and then, asserting the litigation privilege to say what you want, to get what you want. And if that's the way people want in Norfolk County, there are people to prosecute, then God bless you.
Examinesia? I said that again. Cross-examinesia. The question, is it common for a judge to repeatedly bring up the number of attorneys a defendant has? Bev has pointed this out frequently. Like, Karen Reed isn't entitled to have you on her team since she already has 4 attorneys.
No, it's not common at all. Now, in all fairness, is it common to have 5 attorneys? No, that's a lot. On the other hand, look what the hell is going on here. It's a murder case. It's been going on for 3 years. You're fighting for your life. It's complicated. The second time around, the DA is throwing everything in the kitchen sink. They're filing every motion that has merit or no merit to do this, exclude that. There's a lot of work to be done, and they saw fit to seek another skilled lawyer to come in. The judge didn't allow it, and for reasons that don't make sense to me, not that it has to, because she's the judge, she can do whatever she wants. Why that sentence was included, I thought, was not good. That suggested to me personally that there's more to it than just, if you think there's a conflict, then there's a conflict, even though, again, I don't want to get into the inner workings of what a waivable possible conflict and how every I was dotted and every T was crossed and there was no opportunity taken to ask you about it. Put all that aside. But if that's the reasoning, a gratuitous, oh, by the way, she already has 4 and 3 of them are from out of town, that just struck me as unwise. But it doesn't matter. It doesn't matter how it strikes me. She can do whatever she wants. And as lawyers, there's nothing you can do about it. The judge is the judge. You live and die with what the judge does. So that's what you do.
Yeah. Unfortunately, that's a big point. Unfortunately, this judge has kind of made a lot of, that's why we're back for a second trial, because of what happened during the first trial, the way that all ended. And, my thoughts this past weekend is that I'm just interested to see what the defense is going to do right at the end of the next trial after jury deliberation comes out. If there's any kind of a hung jury, whatever, what the defense is going to do in those moments, because it seemed like it just was done so quickly last time. And before you know it, the jury was out of the door, and the defense didn't really know in that moment how to react, and also didn't really have all the facts, I don't believe either, until the coming days when they were informed by the jury about what really happened. And as we've learned from Ronnie, the juror, just how definitive that jury was on counts 1 and counts 3. So it's just like I said, I think that this defense is going to be more wise to the tactics at this time, because I think that when you're in a court that this essentially it was dirty first time around, they pulled a lot, and I think this defense team is going to be even more prepared this time for all of that. So.
Well, they're of course they're going to be prepared, and they're at a certain level, and they have the experience gained from a first trial. And I mean, I wouldn't get into anything else beyond that. Again, that's public, but yeah, I would assume them to be, you know, as our friend Tom Brady would say, laser focused and ready to go.
Right.
Seem common about this defense team is all of them now are pro bono, right? I mean, I think that to the trolls, I throw that back in the trolls' face. Like, where do you see a murder case where all of these lawyers from different firms have decided to go pro bono? I brought up pro bono on this show with you way back, and you like, I felt like you were like, it was like a bad word. Don't say that word here. But then you ended up being pro bono for this. Like,
listen,
does that say something about Karen Reed's defense here?
Well, it does. I mean, look, every lawyer actually, certainly in New York, and I assume it's the case in Massachusetts, has to do a certain amount of pro bono work. That's just part of when you re-register every 2 years as an attorney, you have to do X many hours of pro bono. Now, does that mean you should dedicate, you know, your life to a 2.5 month trial and drive yourself crazy? No, a lot of lawyers wouldn't do that. But I think what you see here is the people involved believe in the case. They believe in the client. They believe in what they're doing. They believe there's a miscarriage of justice. And when you're wired that way, as I am, and those lawyers are, and many other lawyers are, if you're fortunate enough to have the skill level to be desired to participate in something like that, if you're fortunate enough to have a level of success where you can dedicate time, if it's not your normal hourly or fee, whatever it is, and you can do something well and contribute to what you think is ending an injustice, that's not something to be criticized. That's something to be praised. I mean, look, I mean, for me, the only thing that is not disappointing, I guess, is I don't have to live in Massachusetts for like 2 months or 2.5 months, like in a hotel and doing this. So, you know, from a selfish standpoint, that's one of those things that you say, all right, well, that kind of makes the next couple of months a hell of a lot less stressful. On the other hand, you get laser focus, eye of the tiger. You want to do this. You want to participate. You want to work with these lawyers in particular and have a collegial, great cause and do it together. So you want to do all that. And, you know, again, really what it comes down to is time management and whether you have the ability to do it where it doesn't hurt you financially. You know, not everyone can do that. So it would have been a fortunate situation, but it wasn't meant to be. But that was not my choice.
All right. I was just going to say, Mark, that if you had to stay in Boston for a 2-month period, wouldn't this time of year be the best time because the Celtics are practically in the playoffs? I mean, it would be kind of like this is the time, right?
No, listen, absolutely. And, you know, when you agree to do these things, there's a process that goes into this. I mean, you sit there and you say, if this is a 2-month or longer for preparation and how long the trial goes, that's a big deal. That requires speaking to your family. Okay.
What was your family like? Are they happy that it's not happening?
You know what? I have to tell you, they were a little too supportive, which maybe gives me other cause for
Get that out of the house.
No, I'm kidding. But no, I mean, obviously, if it had been a real problem at home, you know, I wouldn't do it. But leaving, you know, a wife and kids and yes, 2 dogs, that matters too, and home.
Right.
And for that, Lola's under. Yeah, she's there.
Lola and Winnie would have been upset. Were you going to take them with you? You can't take them into the hotel room and leave them.
Winnie and Lola would definitely have been upset because around here, I seem to be the only one who really takes care of them. So that would have been an issue. But you know,
I could have helped you find a professional.
I know. No, I know.
Yeah.
But so there's real life considerations that go into this, and when you agree to do it, and it affects other people. And you're right. So the fact that I was going to do that, yeah, I think that's in the plus column, not the negative problem.
Definitely. We get a lot of super chat questions. I don't think I'm going to be able to ask them all, but we'll try. Mark, do you think Bev will have the balls to grant the motion to exclude a third-party culprit defense? This is a great question.
If you are asking me to predict what the judge in this case is going to rule on any motion, my response to you is going to be, pardon the French, I have no fucking idea.
Good answer. What do you think, Baza? Same thing?
Oh, I don't think I can upstate. I'm just going to go with what he said. That works best for me. I think that's.
Let me give a little more lawyerly. I mean, third-party culprit is like a legal term of art that gets way too much attention. Even if that is precluded, you are allowed to argue there's a poor investigation, there's reasonable doubt. You don't have to say someone did it or it was this. You can establish there's reasonable doubt to find that Karen Reed did it based upon the exact same point. So to me, this is all shuffling the deck and means nothing. Okay, the defense is going to be reasonable doubt. And if you can show that there wasn't a car accident and it wasn't her, then by definition, it was somebody else.
Sure.
The fact that you can say it was Colin Albert like this or that, it doesn't matter. So to me, it's not that critical.
Yeah.
Question from Lizzie: has Bunk Bederow, Bunk, ever gone up against any sleazy attorneys as sleazy as Brennan?
So New York, certain quarters of New York City are you have to have real sharp elbows. And you've heard me say this before, over a number of years for a particular time period, especially in Brooklyn, there were some tough customers. It's not like that so much anymore. There were some tough customers. What I will tell you is unique is this. I've never gone up against this guy. I don't know anything about this guy, okay? I don't care that he represented Whitey Bulger. I could care less. I don't care that he decided to be a prosecutor on what I think is a terrible case. I have said the question should be asked from Morrissey, why are you doing this if you have an office full of 50 people? But I will say it is unique in my 26 years of practice to be smeared in the manner without a chance to defend myself,
right?
Not involved in a case by this guy, especially when he's full of shit about what he was saying, okay? That's his problem, not mine.
Yeah, that's a great point too. It's like you said, whether he smears you or not, regardless, it's the fact that you didn't have the opportunity to get up there and speak for yourself and describe, and express the fact that you have ethics and that you have no history of bad ethics. And that seems to be my estimation, listening to you right now, seems to be the thing that probably bothers you the most, is at least give you the opportunity to speak for yourself and not this,
If you're going to come at me, try to keep me out of a case, and you're going to throw innuendo, then bring receipts. And he's got none because he's full of shit. What he alleged was not true, or what he implied. Okay. Yeah. Again, it's very easy to do that in a courtroom without any sworn statements, without any formal opposition. And then to wrap it up as, but I'm not really objecting. I just want you to know.
Yeah, right. I just want you to know. I'm not putting it in writing. I'm not really objecting.
In writing.
The shadiest thing too, Mark, is Maz and I know being around you.
If he puts it in writing, then you can respond, okay, and do things and say things that they could have done, or in the certain circumstance I could have done, but they didn't do it that way. All right. And when he raised issues that were not true, they were addressed in the affidavit that was submitted, the supplemental affidavit, along with a specific paragraph that said, if you have any questions, Mr. Bederow will come talk to you, Judge, one-on-one, and let you know. And if that is relevant to your determination, never happened.
Never happened.
Well,
And we know, Mazza and I know, you don't, you keep things tight to the vest. You are a professional. Like, there's no leaking going on. There's like, even with us, we had no idea that you were representing that you were possibly representing Karen Reed until it was announced to the media. Like, we as close as we are, we didn't know. You didn't let us know. You don't, you don't share shit that you're not supposed to, which I know that for a fact.
Whatever they want to allege, again, and I'm not saying any of this is true either, that there was, they obviously allege to some extent that they believe that there were shenanigans going on between the clients. I mean, that because they, attempted to indict them and they were declined. The ham sandwich, apparently the grand jury didn't want the ham sandwich that day. They make these, and if you want to make those allegations, that's very different than saying that this lawyer must be involved in that, and that's why they're trying to bring him in. That's also a smear on her current lawyers. Let's be clear, as if to suggest, the lawyers are getting together to conspire to do this so that they can share information or whatever. And what is particularly troubling is a prosecutor, as we've talked about this, is the white hat in the system. They're supposed to be. They're supposed to be the one pursuing justice first and foremost, whatever that means in any particular case. And if this is how the prosecutor throws mud around, again, for the people in Norfolk County, God bless you. This is what you wanted. This is what you got.
Yep.
Question from Lady Tammy. She says, what does Mark think of the juror interview? Did we talk? You mentioned that briefly. What do you think about it?
I don't know. I mean, look, there's no dispute that 5 or 6 jurors came forward and said that we acquitted. In fact, in the current litigation that's still going on with that, there's no dispute. I mean, the judge accepted that as true for purposes of the application. So it's essentially a fact in the litigation that the jurors meant to acquit, whether they formally entered the verdict of not guilty or not. But again, to me, the deeper question is how this reflects on this whole place as a prosecuting agency. Just because you can do something doesn't mean you should. The murder charge has always been, we've talked about this, and this is all public, their theory of murder. It's not strong. Obviously, the jury wasn't into it. It bogs the case down. It, adds little and would make you have to believe that, somebody intentionally tried to kill someone right in front of a house full of 15 people and neighbors all over the place, because all the stuff that you heard of, it just doesn't make any sense. And the idea that they are digging in so deep to pursue that charge, even if the court allows them to do it, I don't know why any experienced prosecutor would be trying this as a murder case, but maybe they know something I don't.
Go to this one from John. He says, Video Jesus has credibly shown that Commonwealth likely used spoof X-Core Vision, whatever that is, that player with altered video live in court. What do you think? Hey, did you know have you watched some of the shows that she's done or any of the posts on X about the video, the Sally Port video?
Casually. I mean, a lot of this has come up, in the last week or so. And admittedly, I'm, less focused on that kind of stuff than I might have been a week earlier. But this is the kind of thing that I probably would not discuss. It's not been discussed publicly, really. I mean, I would never share my thoughts and impressions or anyone else's thoughts and impressions about that just because it's not public.
Move on. There's been some other questions here. Here's one. From Z says, how can Bev allow Commonwealth Turtle Boy docs but oppose you, Prohack Vici, due to conflict of interest concerns? Another huge Bev bias like Dr. Russell versus Dr. Crosby. You want to say anything about that, Dr. Crosby versus Dr. Russell too?
Well, that's all in the public records, so that's fine. That one is a head scratcher. Again, and you have to do it in the context of what the threshold for admissibility is and what the role of the court is. You hear all this expert Daubert stuff. The actual opinion of the expert is not relevant to the analysis. It's whether they're qualified and whether they have, you keep hearing the words methodology and it's generally accepted and there's a scientific method and blah, blah, blah. And if that is met, then a judge should say, as kind of a gatekeeper, that meets the threshold. I'm not the finder of fact. I'm going to let that witness render an opinion and let the fact finder, which is the jury, decide. So here comes Dr. Russell, who has a resume that is off the charts, has a ton of experience, familiarity with the subject matter for which she'll be testifying. This is all public. You saw this in hearing after hearing. Explained her methodology, explained all this. I could go on. And ultimately, she's allowed in a very detailed, long opinion that describes it as a close call, which to me is gratuitous, irrelevant language. I'm not sure why you would even say that. But again, the judge can say whatever she wants. She allows it. Then comes Dr. Crosby, and you're using the word doctor for a PhD, not medical. Let's be clear. He's not a veterinarian. He has no, he's a behavioral evaluator, that's not even like hard science, right? That's like, no disrespect, but that's like psychology, psychiatry, more of what you'd call like the opinion sciences than Dr. Russell is a hard scientist. Like we're talking medical. Knee bone is connected to the shin bone means this and all that stuff. And he comes in, no affidavit in support, which is always the way it is with them. Not a medical doctor, which apparently the rules of the road in this court previously were, we need a medical doctor for this kind of thing. And he just gets admitted, not even with a hearing, nothing. It's just, here we go. That's tough to explain. That is tough to explain, but that's not for me.
He doesn't have to. Yeah, double standards everywhere.
Those are your words, not mine. It doesn't. To me, that doesn't logically compute.
We got this guy in the chat. He's complaining about me. He made some funny videos. We've been saying we got to get Joe Flipahead to come out on the show. We want to see what he looks like. We want video of him. Here he is. Joe Flipahead says, Crawford missed my first chat. Great question. Sorry. There's been like too many of them. He says, Bunk, what kind of Lexus was Karen offering you to join the team?
Well,
and then say 3, Bunk's thoughts on destroying the Dream Team slogan by not being allowed on.
So I'm not really a Lexus guy. So even though they might have had an in on that, my price was much higher. So for me, it would take an X7, a BMW for that.
I'd say you look like a Beamer guy.
Yeah. There's nothing to subpoena, fellas. You can look, but you're not going to find any any deals on cars. As far as destroying the Dream Team slogan, I'm sorry. I mean, that's not my fault.
T-shirts are now worthless.
They're like the Patriots, 19 shirts.
Bears shirts where they thought they were.
Well, I mean, look, you have to laugh. I mean, this is all so absurd. You just have to laugh. Yeah. Sorry, but it's not my fault. I tried.
Right.
Mr. Monk's understudy, it says, any comment on how Hank may use Karen's police and public statements to show she has changed her story about who is responsible for John's death?
I mean, he's allowed to, statements of a defendant are admissible, but, based on what you've seen publicly and even on like some of these people who like to mash up Twitter with the so-called changes in statements, I mean, this is like small potatoes, like real small, cut real fine. If this is a prime argument for them, they need to focus on first world problems, not third world problems like this. To me, this is borderline silly. They're allowed to do it. They've indicated they think they are, but based on the so-called inconsistencies, to the extent there are any, which I'm not suggesting there really are, not really, maybe some minor word choices or whatever. This is not going to be the kind of thing that's going to get somebody convicted of murder or some lesser homicide offense. I don't think. That's just my view.
Kevin and Lizzie's Oboe says, Mark, will you be in Stoughton for Aiden on Tuesday?
No, I will be in Manhattan Supreme Court on Tuesday on a pre-existing engagement. So I will be there in spirit for sure. But no, that one will be Tim Bradle without me that day because, it's not that I can't change what I have to do on Tuesday. So not for that one, no. But they're aware.
Yeah, you're before the Manhattan Supreme Court? Is that what you said?
Yeah, in New York, though, Supreme Court is what you would call a superior court. New York is backwards. The Supreme Court is the lower court. Don't ask me why. And the Court of Appeals is the high court. I don't know.
I see. Okay. So it's all right. Lizard says, any thoughts on Hank bolstering Fanning and the look? Thought that was wild.
What do you mean the look? I'm not even sure I know what we're talking about.
The Karen Reed look, where he looked at her when she was looking back.
Oh, Karen kind of looked at each other.
Yes, I did see that. No, I have no thoughts about that. Again, the prosecutor guy, lady in the white hat, I don't know why you would be, having extended stares at a defendant, even if you thought the defendant shouldn't be looking at you. I would think a prosecutor would have better things to do than engage in a staring contest with the defendant. But beyond that, I wouldn't. It is what it is. It's not that big a deal. It's just weird. It's just weird.
Right. Yeah. It showed to me like Karen maybe potentially got in his head a little bit or distracted him enough to kind of stop what he was doing and basically lose full concentration on what he was saying and give all his attention to Karen. It was pretty funny, quite honestly, from a visual perspective.
I don't. Yeah, I've never seen anything like that, but I don't put much stock in it either.
Yeah.
Abacus Blinch asked a question. I'd like to hear Bederow's thoughts on how the Canton Select Board did a switcheroo with the Canton Police Department audit. I thought it was egregious. I'd also throw in, you got John Conley, who's running for re-election against a veterinarian named Susan Harrington, who, Susan Harrington has already said she wants to find a new police chief where the incumbent is supporting keeping Rafferty. Do you have any thoughts on that Canton Select Board or even the audit?
Look, I don't live in Canton. I feel bad for people who do, obviously, given the just craziness they've had to go through in the last 3 years. Your town, fairly or unfairly, has been a national laughingstock, which, again, may very well be unfair for a lot of reasons. But as far as what the local select board should do with the audit, it's up to the voters of the town. You vote for the select board and they deal with the police department and you get what you get. I have no opinion. You said getting rid of the police chief. As I'm sure you're aware, I had a recent communication with the police chief about a matter of public importance. So she responded very politely to that. So I have nothing to say. I have no opinion other than you want the police chief and the police to do their jobs, but you want them to do it fairly and equitably. And it's important that nobody get preferential treatment based on their surname, their prominence in the town, their relationship to others in the town, or any other reason. So, you just, as long as things are done fairly, I don't really care, but it's up to the people who live there. If you don't like these people, then vote them the hell out. That's America. That's what you do.
America. Yeah, absolutely. Before I go to Maz, because I want you to think about this question to Maz, because I know you know a lot about Canton. But Bederow, you mentioned the letter that you sent the Canton police chief. Do you want to comment on that at all? I know it was about Aiden and especially the people being recorded outside D&E Pizza with audio.
Well, it's public, so I don't mind talking about it generally, but let me say this. The letter addresses not just what allegedly occurred on March 4th, it also seeks a general investigation into general surreptitious audio recording. And, I know a lot of people are, oh my God, you must be some kind of idiot for how could you not think this one individual knew that there was a camera. And again, we're talking about a larger issue than any one incident. But what I will tell you and what was addressed in the letter generally, it's our understanding that there are 2 cameras at that location, and that the one that certain people might have looked into and saw is not the one recording sound. That is a separate camera outside, positioned quite far away, and that any individual may not know that that camera's there at that time or that it's audio recording. But there's been a lot of online banter, and the Twitter lawyers are out in full force. And what people need to understand about Massachusetts, their wiretapping statute is it's pretty harsh. All right. Where I live now, it's a one-party state. This would be a non-issue. So you can, record away as long as you're participating. But people talk about, reasonable expectation of privacy, and you don't have one in public. That's generally true. And that applies to the Fourth Amendment to the United States Constitution about, all kinds of issues related to criminal procedure and search and seizure, and whether, the police acted lawfully. If you look at the Massachusetts case law, reasonable expectation of privacy is not the issue. You don't have to have that. The issue is whether all, not 2, all participants to an audio communication, okay, have actual knowledge that they're being audio recorded. So if there are 3 people walking down, I don't know, Washington Street in downtown Canton, where there's a pizza place and a bar that are like situated next to each other, and if 3 people are walking down that street together and somebody overhears with your own ears the conversation, well, those 3 people didn't have a reasonable expectation of privacy. That's entirely true. You don't have a reasonable expectation of privacy if you're yapping in public and you see somebody over there and they're listening to you. But Massachusetts law requires for the device that all participants to the communication have actual knowledge that they're being audio recorded. And I'm here to tell you that 99% of the people who walk down Washington Street have no freaking idea that any local business that has a little tiny camera stuffed in the corner is audio recording. Okay.
I would never think that. I would never think that a business on Main Street basically is recording people.
In Massachusetts, you are not required, because you're walking down a public street, to have your head on a swivel and look at every awning and every door before you say anything. So this can relate to people that are walking down the street. This can relate to people who are just standing on the sidewalk, having a conversation, and the eye in the sky, or I should say the ear in the sky.
Listening. He's listening.
Okay. And it's recording and it's capturing. And under Massachusetts law, that is illegal. Okay. It's also a misdemeanor crime in Massachusetts simply to have such a device. If there's the intent to use it in that manner. Okay. Now you can get into, well, what about Ring cameras, all that, all you want. Okay. I look, I don't live in Massachusetts. Okay. So my Ring cameras, they're one party. I don't really care. All right. And I think, people say, well, that can't be the law with these Ring cameras. Well, you need to make damn sure. I don't know. Massachusetts is different. The cameras that were at issue here on their website have a warning saying, don't do it. Don't use it for this purpose.
Yeah, I think it's different too. If it's like, it's one thing if it's your house and it's set back and people are going to the door and they see the Ring camera there. They immediately know that's probably recording, especially when the light goes on.
Bottom line.
Yeah. And it's not like unexpected when you go to someone's door, but when you're on Yeah, when you're in a public street in front of the, in the central business area where there are restaurants, you don't expect they're recording audio on the sidewalk. I never do. I would expect some video to be recording, but not audio. Now, that's like very unusual. A business to do that to the general public, that's not normal. That is not, yeah.
So
I don't know how they get away with that.
What real lawyers do, and perhaps some, but not all Twitter lawyers do, is actually look at the law, look at the statutes, look at the case law, and apply it to a set of facts, okay? And the Massachusetts law couldn't be clearer, okay? All parties must be aware. The standard is actual knowledge. That's the law, okay? I don't know what the law they teach at the law school of Twitter is, but that's the Commonwealth of Massachusetts law. And if the law, if people don't like it, then the law should be changed. Okay. If you don't want to apply it, then the police department should explain why. And this goes back to the point from 15 minutes ago. You need to be equitable. You need to be fair. You need to explain why this business or any business is allowed to do this, but other people are not. That's all. You want fairness and equity in policing. And if you don't like that, and you don't like the select board who go to the police chief 20 minutes later, vote them out. That's all.
Yeah, and transparency so that people know what the rule and the law is in Canton. Apparently, like, is it change if your last name's Albert compared to everyone else? Like, how does she decide? Since like that, like that's what I want to see. I want to see how she, like you said, transparency. We want to know. Mazza, you want to comment on that or anything around Canton, around the select board, or even the Canton police audit?
Yeah, I'll talk about the Canton Select Board. I think that one of the ongoing concerns for the residents has been really replacing seats from individuals that have sat in those seats for quite some time. I know about a year ago, there was a really big attempt to at least seize one of those seats. They were successful with maybe some mixed results from some of the townspeople on that individual who got the seat. But, I'd say at this point, I think their best effort is to continue to do what they're doing, which is to continue to contest and contend. And anytime somebody runs, whether it be Mr. Conley or John Conley or somebody else, to contest them and run against them and try to replace that seat any way they can. I think that's their best opportunity. It might not be sometimes that short-term change that you want. Sometimes it might be more of a long-term strategy over a multitude of a few elections and unseating people that have been there that typically are not considered too favorable by people that typically are free Karen Reed or people that were essentially just maybe generally fighting for change in Canton. And I think that's their best approach, is to continue to run, continue to get the voters out there and spread awareness in the town about what they want to change and change the town from within. And if there is a level of corruption there, it appears to be more than obvious. The best way to do that is to eradicate it in areas where you can have an effect on that. One of that's running for office.
I hope the candidate Susan Harrington does defeat Conley.
Yeah,
she is great. She's a forward thinker. Like she basically predicted the Sallyport camera issues. She was focused on video, who has access to it before that even happened. Like, we have video of her. It's crazy that she was so on point even before that became an issue. She's become, she's making it even more of an issue. So I really hope that people are tuned in and paying attention and go vote there. Here's a question. Oh, go ahead.
Let me do it real quick, just on the Sallyport video. I don't know if you remember this too from way back a year ago. That seems to be the common refrain tonight. I told you way back then, when this whole inverted video became a thing, that's going to be what does it.
It's become so contentious too, like in terms of that video.
That was going to be an issue if there was another trial. That's just going to be so important, and clearly that is the main thrust of the motion to dismiss that they filed. So
the question kind of related to that, thoughts on requirements to provide metadata, and do we need stricter standards with the existence of AI? That was proctored and doctored who asked that question. There's been a lot of back and forth about this metadata related to that Sallyport video and other video.
Again, the prosecutor always should wear the white hat, should always be interested in the pursuit of justice, and should always follow the facts wherever they go, even if it takes the prosecution over the cliff. You have to try a defendant fairly and honorably. And there are real serious issues that have been raised for years about the integrity of the police, the state police, the Canton police, the Sally Port video. And there, as you now know, this is all public. Video gets disclosed in drips and draps. Now you know that the DA claims we didn't even know about the video, but Proctor held it. And yet they continue to fight, clutch, grab, and try to suppress the disclosure of very simple information, which ought to give a digital footprint of who had what, when they had it, and where it went. And the question that anyone should ask is, why would a prosecutor do that? Why would that be something that you oppose? Are you afraid of where that's going to lead? Is it going to lead to the DA's office? I don't know. Nobody knows because they can't get it, apparently, or they won't disclose it. But the way they fight to turn that over is really disturbing.
Ashley, you want to make a comment on any of that data that's being withheld?
I'm going to pass on that. I just think that comment I wanted to make was getting back to dismissing the case from the judge. I don't think that that's ever going to happen. It's a comment just made by VR a few moments ago. I just don't think the judge is ever going to dismiss this case, and I think that she's going to push to trial no matter what. We've seen her push the timeline, and again, it just seems to be a no-win situation in terms of getting any kind of impartiality out of this judge whatsoever. Yep.
I can tell you, as a matter of, I think, logic and common sense and how judges, I'm speaking generally, do things. When there is a motion of what I'll call finality and about 27 other motions of non-finality, it would seem you determine the motion of finality first, because if you in fact terminate the case, one need not reach the other motions. But yet other motions are being determined first. There is a trial date, which is 2 weeks away. The defense requested an evidentiary hearing and the right to call numerous witnesses, which are highly relevant to the motion to dismiss. And there's been no suggestion of that hearing or anything. So, you know, I don't like to predict these things too much, but it doesn't sound like she intends on granting the motion to dismiss.
No. The lawyer, you know, gave it less than a 2% chance, and I think even he was pretty much admitting that he was being more than fair, more than optimistic about that, even being more than, less than 2%. But it's just, it's something she's not going to do.
That motion, by the way, is certainly in my view, and it's all in the record, so you can draw your own conclusion, quite compelling. This video evidence or lack thereof is highly, highly disturbing. And of course, as a legal concept, the way Brady and Discovery works, their response was stunning for the simple reason that it was, it ain't me, babe. Like, we never touched it. We didn't know. But when I say we didn't know, I'm speaking literally the Norfolk County DA's office, separating us from the Canton police and Massachusetts State Police. But in a legal sense, and this is black letter law, every first-year law student who studies criminal procedure knows, the prosecution, it is imputed to them if evidence is in the possession, custody, or control of an agency that's working with you. In other words, the police. Prosecution is as responsible for the police in a legal sense as if they protected it or possessed it themselves. And yet the whole thrust of their response was, do not come to the DA's office. We don't know what you're talking about. Blame it on them, which is legally not an argument. That was a fact-based, almost PR type argument.
Few other questions. I'm looking for the one that I saw earlier, but I know what the question is. I'll probably throw it up on the screen again. But they wanted to know if you ever been disallowed to practice, for a client like you have in this case. Has it ever happened before?
Of course not. No, I don't know any lawyer who has never been sanctioned in any place who has ever been denied. No, absolutely, positively not. I have been admitted pro hoc vice in this very court on 3 other cases, obviously. I've been admitted in some federal district court, outside of where I practice. I assume if I was called for cases in 48 other states tomorrow and had a sponsoring attorney there, I would be admitted without issue. No, the answer is no. I've never seen this. I've never heard of it. It's never happened to me. I've never heard it happening to anyone else. Absolutely, positively not.
But of course, the one time it does happen, of course, it's the Karen Reed case, which has always been nothing but fair and partial.
Without an opportunity to be heard when there was a non-objection objection raised about a conflict of interest, and I announced that I had waivers. They were what we call informed waivers with other attorneys, separate and apart from me, in writing, explaining, presenting the rules, and I will volunteer myself to speak with you ex parte. And that offer was rejected. So with that caveat, no, of course I've never heard of anything like this, and I don't expect I ever will again.
Yep. Well said.
Beach. Could a jury from trial 1 be a read witness? Not possible.
No. A trial witness? No. I mean, what could they testify about? No.
The jury tampering stuff? No.
That's not an issue in the trial. I mean, that's a procedural legal thing.
Right.
No, that's not. The trial relates to whether there's proof beyond a reasonable doubt of her causing, John O'Keefe's death and da-da-da-da-da.
Jay Beans wants to know if this experience has changed your opinion of Spanky and Bev. Hank Brennan and Bev, the judge.
No, of course not.
I love it. You know what? It's so funny. The no comments are giving a lot away. I love it. I love that when you
next question.
Next question. There's been a few on the FBI. I don't know if I should put those back up. I mean, people are asking it in new ways.
You can try to ask in different ways, but I'm not
asking it differently.
Now, this is a good one. Edward says, 2 dogs, Winnie and Lola. Don't you mean it?
No,
we don't mean it.
Girls or boys, they are never it. That was one of the weirdest things. Again, if you're a dog person, you would pick up on that in the first trial, where some of the witnesses spoke about their dog that they got rid of as either the dog or it. That was weird to me. But again, draw from it what you will. Just as a dog person, I found that bizarre. But
yeah,
Lizzie has a follow-up question. She's asking about Brennan. If he lies in front of a jury, what if they believe him and Bev lets him do it with no repercussions? Can you register a complaint?
So lawyers, what they say is not evidence, and what they say in court is not sworn, and that's part of the problem. Certainly in the pretrial hearings, you are supposed to support motions, affidavits, and, give a set of facts that in some ways, lock you in to not being reckless or careless with statements. Obviously, if a lawyer says something during the trial in a summation that misstates the evidence or is just blatantly false, the other side can object. And, depending on how the motions in limine go, you can either go to sidebar, or in most courtrooms in America, you can say, objection, that's not in evidence. I mean, like in New York, if he did that, you'd stand up and say, objection, that's not accurate. That's not going to turn everyone into a pumpkin in the jury box. But, in this trial, it may be that you have to object and then go to the bench and explain a sealed transcript why you think that's improper. I think it's very important for the defense, and probably for the prosecution too, that motion in limine be granted and she just come out of her comfort zone and let them state their objections. There's no reason they can't. I mean, you're going to shorten the trial by probably 6 hours if you just let them. What I found one of the problems with the first trial was, and at least had some degree of concern about under the theory I might have at the time participated in the second trial was the just lack of flow, the lack of cadence. And by the way, I'm talking about more like transcripts more than watching. But when you look at some of the transcripts or whatever you're reading, you can just see how it gets bogged down with the constant interruptions and sidebars, and it was almost like PTSD on how to try a case, that there's very little flow. And hopefully for the second trial, and that's for both sides, there's just more cadence and flow. I think the jury will benefit, the lawyers will benefit, the viewers will benefit because it'll be quicker and easier to follow. But I guess we'll have to see.
Right. Yeah.
Question for both of you. What's the best way for the defense to tackle the taillight evidence if they try not to lean in too much to the framed aspect?
Well, again, going off what's in the public record, the taillight, according to the prosecution, certain pieces of the taillight were found, buried in the snow at 34 Fairview Road at about 5:45, give or take. I think the evidence at the trial or in the public record is that the car was in the Sally Port by about 5:31, 5:35, something like that. Off the top of my head, I don't even remember. Kind of flush a lot of the detail when I have other things to do now. It's just the reality if I'm not trying this. So obviously the timeline matters, right? And you take the timeline back to the car being observed in Dighton and being towed. And it turns out the truth is there is opportunity for the car to have been in the Sallyport and taillight to be transferred a mile, 2 miles, whatever it is. It's a very quick ride. If you've ever, I'm sure 90% of the people listening have actually been taking the, Canton Ghoul tour, if you will, around and gone to the sites and whatever. And it's a couple of minutes away. It's entirely plausible. Okay. And then you go back and you see that, Michael Proctor made falsely sworn statements about that timeline, which would have made it impossible. That's not in dispute, whether you call it a scrivener's error or a typo like 7 times or whatever it was. You find out the time that these pieces were actually recovered. You find out that there were unknown persons who were part of that search, which makes no sense to any sane investigator. You call out a team, but then you have 5 unknown, unaccounted randos participating in the search. Who the hell were they? Then you factor out they only find a couple of pieces in the snow, and it's day after it's melting, but no one else finds any. Nobody walking dogs, nobody from the home, right. Nobody, just the usual suspects, as they say. And that you're halfway home to reasonable doubt on this alone, really.
Yeah. And then you have Sallyport, then putting it in the Stop and Shop bags, collecting it in solo cups, and just letting it sit there unattended for hours or days on end. No true report on who was having access to that particular building, who was, key carding their way in and out during those durations. This evidence of it in itself is almost, in my opinion, should be inadmissible because it's not really well-preserved evidence. It was a crime scene that was not well-preserved. It was closed down very quickly. And then on top of that, they're allegedly finding taillight weeks afterwards when a now deceased police chief at the time was traveling down the street. And they're just finding stuff here, taillight there, taillight everywhere. And it's very, very much a farce, in my opinion.
You make a really valid point, in the simple reason that if the police had handled this properly from the jump, in other words, secure the crime scene, okay? And by the way, it's not like the movies. You don't need to have a SWAT team out there. It could be something as simple as one Canton police car sitting there to make sure nobody diddles with the crime scene. That's it. Right. And if somebody comes by, get away, move on. That's it. If they had done that and they could establish that the scene was secure from the get-go and that it was impossible for anyone to plant evidence or do anything, then that taillight that was there, most normal people would say, well, that taillight was there. But they didn't do that. And they didn't do 100 other things. They didn't photograph it in Dighton. They didn't tow the car or document the right time they did. I mean, you could go on. And all of these things add up to very likely, certainly in my view, a reasonable doubt just as to the integrity of the taillight evidence. And if that evidence on top of ARCA and all that other stuff, I just, to me, I don't see how they ever get past that. I've never understood that from, a year ago.
We've had a number of questions about what Mazza said, excluding that taillight. Is it possible that they could ever request that they just exclude that evidence because it wasn't protected?
No, no, it goes to the weight, not the admissibility. And obviously, in any case, the defense would just argue it's not reliable because they didn't secure the crime scene. And on top of that, this is the other key point. The timeline is entirely plausible. There is an opportunity for somebody to have sprinkled taillight. There are many other questions that, people could ask, who saw the first trial. It's all public. Story's not going to change. Is, how the hell did they find, these 3 or however many small pieces in 10 minutes buried under all the snow the way they did? But when the Canton police were there in much less snow, it wasn't compacted, it wasn't plowed, it was fresh. In the area where they found the blood, they found nothing. Now, the area where they found the blood, one would assume would be the area where you'd find the evidence, right? So, you could go on and on with this stuff, but these are just points that the lawyers that are trying the case will have to emphasize. They will, the DA will say whatever they say, but I don't think there's ever a great answer for that, unless you want to say that the defense would have you believe that, everyone is wearing a tinfoil hat and it's but again, you go where the facts go, and the defense has no burden of proof, and they're poking holes here. And they have the benefit of the first trial. This is why I always told you even a year ago why the retrial is going to favor the defense. The people who testified about finding the taillight, that story can't change. Okay? They can do whatever they want with we're, the telematics and this, and we're going to exclude that. The story of what people literally did and when they did it cannot change.
Speaking of changes, the prosecution witness list is out. Some of the names have changed. Caitlin Albert is not on the list.
Yep.
Why do you think she might not be on the list this time? Why are they not bringing her back for trial 2.0?
Look, if you want to give them the benefit of the doubt, they think she has nothing to add. She would say, I was in the house, I didn't see anything. And yes, it's true, I left, much later than apparently my parents told people previously. But in any event, my now husband, then boyfriend, whatever he is, picked me up and home I went. It may very well be that the DA just doesn't see the point in even, look, anyone in the house who didn't see anything, I can understand why they, again, whether you believe it or not, I can understand why the DA might not want to call that. I don't think them not calling Caitlin Albert is that big a deal. I get it. She, from a prosecution standpoint, offered, I think, if I recall, literally nothing. Now, the defense is going to want to call her because she's got a friend or acquaintance or whatever you want to call her. So you better damn well believe that's going to get revisited, right?
Yeah, you bet. You bet. It could be one of the biggest reasons why I don't want to call her back, just for that very sense.
Right.
Yeah.
But the defense can, so they're not going to be able to avoid it. So that's why. So she'll definitely, I haven't seen the list. I don't know what it literally looks like, other than I'm obviously aware that, a client was put on it for some reason. But other than that, what were the other oddities on the list? I don't even know.
Now, on the Aiden part, Have you already, or are you requesting that he be allowed to cover the trial? How does that work? Because I know that's the biggest fear
So
that wants to do. So how does he combat that?
all of the issues related to him will be dealt with, but that'll be dealt with in a different forum than that.
And here,
that's behind the guardrail. Yeah.
Oh, perfect. That was a perfect answer.
Yeah.
Love it. It's a comment here from Julie P. She said, "Hi, Mark. I saw you when I was watching 2020, the episode the other day, Undercover Mother. I was like, I know that guy. You were on Undercover Mother. What was that about?"
Yeah. I've done a couple 2020s and 48 Hours, all those shows. That relates to the Brooklyn case that we talked about, where she went undercover to kind of chat up a juror, and then the case that went up and down the courts for umpteen years. Yeah, so that case was featured on several episodes of 2020. Dr. Phil, we went out to California for that. Yeah, that was kind of a big case in New York for a number of years. That's the one they call so-called grid kid killer, who was accused of killing the college football player in Brooklyn.
And getting corrected. Apparently, I screwed that up. Allie is not on the list. Caitlin is on the list. So it's Allie McCabe.
Okay. Well, I understand why they don't want her on the list, because it's kind of messy, as I recall from the first trial, with her so-called Life 360 didn't really mesh with her testimony, and then you had the kind of screenshot rather than real text. And I think from the DA's standpoint, why allow them to cross-examine that? Make them, if the defense wants, you have to call her, and then you have to direct a witness rather than cross, and that's much harder. So I understand why they would do that too.
Mo asked a great question. Do you think the defense will call the Dighton cop, Nick Barrows? Do you think they'll call him?
Not going to speculate and get into it. I can't talk about that. I'm sorry.
I think so. I'd imagine they will, because he was such a great witness. He was a better witness for the defense. A lot of people actually were better witnesses for the defense, even though they were Commonwealth witnesses, I thought, last time. But yeah, definitely bring him back. He was a very, very great witness. He had a lot of information to provide, and I think he has a lot of statements that can be made on the stand that could be very pivotal. And I'd imagine that the defense, noticing that he's not on the Commonwealth list, they're definitely going to clean that up and make sure he's on their defense list. So yeah, bring on Barrett.
Yeah, I mean, I'm not going to talk about any defense strategies or what they might do. I don't think that's fair to them. And, I was in a unique situation, so I'm not going to do that. What I would simply say is if he's on the defense list, then they are asserting their right to do so. And it doesn't mean they will, but, they would absolutely have the right to do that.
Question I would have, too, a follow-up question on that we won't know. But I just wonder is, will he talk to the defense? Will he, I'm sure they're probably sending private detectives or whoever to go talk to him and ask him some questions. And because I think they could have asked him a few more questions on the stand, but they didn't know how he's going to answer. So I just wonder, I think a lot of police don't generally talk to the defense. I wonder in this case if he would actually discuss it with them before being called.
I'm going to let you guys chat about that one. I'm going to sit that one out too.
Yeah, I don't know. What do you think, Mazza? You think he'll talk to the defense?
Repeat that?
Whether Barrows, last time when the defense questioned him, they didn't know what he was going to say.
Right.
Most cops generally don't talk to the defense,
Right.
So I just wonder if the defense approaches him like now or the last month or two, whenever, if he is willing to talk to them and give them information,
Yeah, I think that's a great theory, and I hope so. I hope that he was, if they're able to speak with him and talk with him and get some information, I think that would be fantastic. So yeah, I hope so. I don't know, but I'd say I'd hope so. And if they're able to, I think that'd be a great strategy for the defense to do that. And I hope that Barrows was able to be willing to do that. I thought he was very balanced. He was actually, I thought, of all the witnesses that were listed for the Commonwealth, he was the only one I felt that had that balance where he wasn't really somebody you looked at as having a side. He just kind of went up there and kind of just presented himself. There was a few other people I had actually seen on there too that were people most of us have forgotten about that were able to just kind of give a testimony or tell us what they knew and leave it at that. But I thought Barrows was definitely someone of huge value. So I hope they did. I hope they did reach out to him, touch base with him, and have a conversation and see what kind of information they can get. Because, like I said, he had a lot of good stuff to say, and I hope, all that good stuff. So, but yeah.
A has a question. How does the defense counteract all the needless testimony? Lally, it was snowing, and keep them focused on actual facts. I am so sad to have Karen lose you, but selfishly so happy to have you back.
Well, that's nice. Thank you very much. I think a lot of the problem that's raised in the question that will be handled by Brennan. I mean, I think he understands perhaps more than Lally the effectiveness or the cadence of a trial. And I would assume that he will trim the fat based on years of experience in trying cases to realize having 27 witnesses talk about, the band was playing, there's snow on the apron, we shoveled the snow and this and that. There's just no need for that. I think it'll probably correct itself. I don't think the defense is going to have to do that. I think the prosecution, that whatever else you think of Brennan, he understands that.
He'll streamline it.
Yeah.
Here is another one. Annie says, please tell me the defense knows about the taillight diffuser. One Meadows ring cam video proves the diffuser was intact, yet they found parts of it at the scene, proving the tampering.
I mean, look, I'm not going to comment on what they know or don't know or what it all means, other than to say there's a lot of video of the taillight in question. And there's a lot of different video which shows areas that may be lit, area that is not lit, and what that means, like, again, whether it's diffuser lights or whatnot. And it speaks for itself if it's explained to the jury, right? I mean, and then, let's also not forget one of the real troubling things perhaps with the inverted video is after they inverted it and, fooled the guy in the attic and all that stuff, getting excited about it. Don't forget that the color of it almost looked like it had been adjusted in a way to look, and this is the wrong taillight. This is important.
Right.
It looks like they took one of those glow pens or like the highlighter pen.
That's troubling. But as far as the diffuser and the light, I mean, that's just a matter of freeze framing video, explaining what it all means and making your point. And again, from the defense standpoint, having the benefit of just creating reasonable doubt, not having to prove what it is. So that's a problem for the prosecution. If a jury says, I don't know, that's win one for the defense. And that's a big point.
Right. As this jury too, they need to, be really grinded into understanding reasonable doubt in this matter. It seemed like on question two, second, count two, they didn't really understand reasonable doubt enough. And I think that's definitely something that I'd like to see the defense. And I don't think they need me to preach to them. I think they already know what their strategy is going to be, obviously. They're probably going to sprinkle that a little bit more, especially now already having a previous jury as a sample size for what kind of, like Juror Ronnie. All the feedback he gave, I'm sure, they talked to him on the phone, I'm guessing at some point before he was even, on Aiden's show or whatever. But that will be invaluable for them to kind of tailor that, because not only is he going to provide feedback on what he thinks, but also what that jury thinks and how that jury reacted. And I think it's going to be extremely beneficial. It's going to be very intriguing to see how the defense, what they do the same this time and how they alter their approach this time based on what they've seen, what did work the first time and what also maybe they might have wanted to tailor going into a second trial. And I think definitely getting that jury to understand reasonable doubt and understanding when it comes to blood alcohol level, tail light, whatever, that there's more than enough reasonable doubt, no pun intended here, but sprinkled all over this particular case. And again, that's it. If the prosecution and the Commonwealth cannot prove beyond a reasonable doubt that Karen Reed did it, then reasonable doubt has been established that she cannot be convicted on any one of those three counts. And I'm looking forward to seeing what this defense does, because I'd imagine they have a very nice revised game this time around from last time, and they're going to tighten things up even more now that they had that sample size from that previous jury.
Question here from Lola, the good dog. I think your dog has parody accounts now. This is funny.
Do you hear that?
Mark Bederow's thoughts on Bev's. Yeah, you're looking to see if she's posted. Mark Bederow's thoughts on Bev's gravely concerned moment.
It's one of the most regrettable things I've ever seen a judge do in 26 years. There was no moment to be gravely concerned about anyone's ethics with respect to the ARCA issue. But more importantly, to the extent that there might have been, okay, what you don't do with everyone watching is express that, in my opinion. I can respectfully disagree with the judge here. Express that view publicly, and then shit can the rest of the day and say, we're out of here, and not even offer the defense an opportunity to respond. Now, I can get, maybe you want more time to respond, but what you don't do is say, leave it hanging that I'm worried and I'm concerned about, lawyers' pro hoc status and other ethical concerns, because the idea is, it's obvious that's going to be in the press, jury summonses are out, that sort of thing, and the prejudice that could attach to any defendant in that situation, and the defendant's lawyers of choice, including her lead counsel, by the way. I think that was highly, highly regrettable, especially as it turns out it really was, much ado about nothing. And also a lot of it was predicated on, the so-called 9 or 10 factual misstatements made by the prosecutor. And I think, again, that was really disturbing to me in the way that was handled. And that's prejudice you can't get back necessarily. So
playing to the jury watching at home. That's what it felt like to me.
I'm not going to say that she did it on purpose for that reason. What I'm saying is, but what she did was create prejudice that need not have been created. And that if there was anger or concern, the irony is, in that courtroom, everything's done at sidebar quietly. And what could have happened is, step up, I'm gravely concerned, I'm really worried, and said to the defense, I'm going to give you the opportunity to argue now if you want, or I'm going to give you a chance to come back on another day. We'll call it a day, and then just leave it at that and say, okay, after discussion at sidebar, we're going to adjourn for today. We'll pick this up again. There was no need to say it publicly and then not even give them a chance to respond. Maybe they were going to respond right then and there. Now, in hindsight, it works out fine. The more time you get, you prepare, whatever. But yeah, I didn't like it.
Like what Brennan was doing. That's what, when I said that too, I was really referring playing to the jury for Brennan. But
that was another
bought into it. Yeah, that was different.
But that was another example of, it's similar to what he did in my situation. Okay.
Exactly.
Said this material all came from the U.S. attorney. And only when the judge came back, he got that real sheepish, oh shit, what did I do? It turns out it was from the defense. But how many times can these little mistakes happen? This is a highly, highly experienced attorney. Okay. He knows what he's doing. And you have to remember that whole thing about getting it from the feds, that was preceded by about a 15 to 20 minute windup. All right. That appeared to be well prepared, about the dark hallways of TUI and all, these are.
I know about TUI. I know a thing about the feds. Yeah. Right.
Those are sound bites that were pre-planned. Okay. That was for public disclosure. So, and I don't really care about that, other than how could you not know if you wound up for 15 or 20 minutes that it wasn't true? I'm even more disturbed by the other two prosecutors who had to have known that he misspoke, who didn't call a timeout and call him over and say, no, No.
That's not right. That's not right. Yeah, really.
As officers of the court, they're obligated too. They're ethically on the hook if they know that there's a factual material misstatement being made to correct that. And he didn't correct it until, the judge came back. And you saw this with other stuff again and again. And I just think that's what ought to be a matter of grave concern to the court, not this arc of nonsense.
Yeah.
Another question came in. What is your opinion of Nan Gallagher's efforts in commentary with the content creators? What was it like to meet her?
Very nice person. Look, all these people who are supporting, I think it's great. Some are certainly out there louder than others, but you have to understand, I laugh because if you're like New York, New Jersey, that's how you are. You're going to be out there, and you're going to be out there loud and let everyone know it and not care. And that's what she does. So more power to her. And, she triggers, I know, a lot of people who don't like you guys. So I get a kick out of that. But, you must be doing something right if you're triggering all these people about, your intelligence, your physical appearance, your use of filters or non-use of filters. I mean, all the real important stuff.
She gives donations to us. That's another one. She really gets people mad that she spreads out the money to the content creators.
Reverse grifting.
We love it.
Look, I don't know why they care. I mean, I guess a lot of these people care because, a lot of them don't have two nickels to rub together.
Yeah, they didn't like when she basically bought me a new computer, this beautiful computer I have. I like to rub it into them. They get very upset about that. Thank you, Nan.
Don't know why he's so triggering, but I didn't think a year or so ago when we started chatting that having the temerity to have experience in this world and having the gall to think that this is not a strong prosecution and may even be an unethical one would be so triggering to people who disagree. Where I come from, you agree or disagree and you move on. It is what it is. But wow.
Yeah. Some people like the Yankees and some people like the Red Sox.
Right.
It is what it is.
Right. It's not the Yankees fans' fault for being morons. It just
that's
the
right.
way.
Right.
That's exactly right.
Like George Steinbrenner and come on.
Yeah, Nan's Nan. What I liked about Nan was her reaction to all these trolls on X. Because Mark, I remember when you were really starting to kind of appear on shows last year, the trolls were really starting to eat you alive or not eat you alive, but would come after you for the first time. And it was interesting to see her reaction to it was so similar to yours, that they just come out of nowhere at you guys, especially being attorneys. And you guys are a big threat because you have actual people that practice law that are saying what we're saying. And when you guys come on our shows and we have a level of agreement that validates what us on our side are here to say, and we greatly appreciate that. I know it's been a lot of times. Yeah, go ahead.
It was a very new experience to be, criticized as, with all exclusively practicing criminal law, prosecutor, defense attorney, in courtrooms in Manhattan, which are, essentially the best in the country, the bar, I mean, the legal world, it's the, creme de la creme, to be criticized as, by, some unwashed man in an attic as a real estate lawyer, a grifter, and I think recently ambulance chaser, and,
that was today on my thing. It's funny though. He says real estate grifting attorney, and here's Rich Vestine, who's like the best dude ever, your friend, who's probably the best real estate attorney around. He's exposed major frauds, title frauds going on. Rich is the best guy ever. And it's so funny when they mention that. He's like, here I am. It's funny. Like, what's wrong with, there's nothing wrong with Rich Vestine being a real estate attorney. He's like the best thing ever.
I mean, listen, any 10 drunks in a bar and all that fun stuff, that was all fine. The part where you lost me, and actually I found, I mean, look, if you want to, hang out in the attic and give your versions and theories, more power to you. But when you're going to shit on actual real experienced and skilled lawyers, let me give you a pro tip. Don't give a mock closing argument, okay, that sounds foolish, wearing a wrinkled shirt and a crooked tie. But more importantly, don't give your summation before the other side has even had a right to be heard in the trial. See, the way a criminal trial works is after the prosecution rests, the defense gets a chance to speak. Now, they may rest right away, but in the first case, they didn't. They actually put on evidence and actually, they sum up first. So if you want to give the prosecution summation that you worked hard and spent all those hours on and criticize all the real lawyers who kind of know what they're talking about, at least give the defense a chance to speak before you take out the wrinkled shirt and crooked tie and stand in front of the mirror and tell the world, what you would argue proves the case beyond a reasonable doubt. That's when I just realized we really are in the upside down bizarro world with this case. But
we don't even get to hear any of the expert witnesses. No ARCA, but he's already doing the close.
He summed up for the ARCA. I mean, look, we're just having fun now, but the point is there's just this constant nastiness. I mean, that was so gratuitous with like the recent ambulance chasing, and I just
he's jealous. He's mad because he's jealous because of the show tonight. Like that's that's all about. Kevin's looking at his show. He's got 100 viewers on a good night, and he knows the numbers that are coming in tonight. That's what it's about.
I just, it's a free country and criticize, but if you're going to enter this world and criticize the real lawyers, at least have a clue on how it works. That's my point.
That's a great point. That's a very great point.
I don't pretend to criticize how to mix drinks and things like that. And I wouldn't do that because that's his world. Or used to be.
Yeah. Or if someone's an auto mechanic, I don't tell them how to fix my car. You know what I mean?
Sure.
It's just, or my dentist. I let them tell me what they're doing. That's it. Tell me what you're doing. Cape Cod Cred says, can Mark Bederow give comment on the amount of times a judge has been overturned?
I can't because I have no idea what her reversal history is. And I don't even, is it high? I'm implying, is it high based on the question? I don't know. I know nothing about it, literally. I just don't know.
There's 2:27 a.m. Search happens. Has a comment question. How should the defense handle non-speaking objections if their motion is not granted? Should they ask for sidebars every time? Yeah, like Carl Steinbeck is an attorney that came on the show. He suggested that if the judge doesn't want to do that they gum up the works more by asking for sidebars every time. What do you think?
Listen, you have to play by the rules of the road of the court. And if she's not going to let them give what, in my experience, is a customary thing to do, which is just object. And if the judge doesn't make an opinion right away, state a reason or have a minor discussion in front of a jury, it's not usually the biggest deal. If she's not going to let you do that, then I agree with that. I said, okay, this is how we're going to do it. Then guess what? Buckle up, crack your knuckles, and let's go. And we're going to get our, wear your Apple Watch because you're going to get your 20,000 steps because you're going to be going back and forth to the bench. I mean, they have a right to make a record, and that can be important on a possible appeal. You have to preserve an objection. And if an appellate court doesn't even know the basis of your objection, there's the risk that you didn't preserve it or they won't be able to articulate it later. An appellate lawyer may not even agree with your purpose in objecting or what you were doing. So, yeah, I would really hope that she would just let the lawyers object. She could even say you don't have to do it where you allow speaking objections. You could say, if you object, I will ask you if I want your reason, but there's no reason to do that at sidebar every time. Now, there may be reasons why a party wants to do it at sidebar because it could be prejudicial. But if you're talking about hearsay and things like that, or leading the witness and that just get it over with. Like, you don't need, the jury is not going to be impacted by hearing that.
Back to Joe Flipahead. He said, I would probably allow it on the papers unless I know there's an opposition, but that's rare. Word for word from Bev about bunk.
Well,
I decided to not follow him on the papers with no opposition.
I don't remember the exact words, but I do remember when it was first brought up that she basically said words to the effect of, I'm prepared to just do it if you don't care, but I just need a different affidavit for whatever reason. To be clear, and I know we beat this to death, there was no opposition, okay? That was a non-objection, objection, needling, throwing out false, in my view, statements about my integrity or what I would do or what I had done. But at the end of the day, after all that, I don't object. There was no motion submitted in response. So that's what she said. That's what she said.
Couple of questions I'm going to throw at you. Who would Bederow have wanted to cross-examine most had he had the option?
Yeah, I wanted to know that. That's a question I had. Yeah.
Well, so to be clear, okay, these are not discussions that I'm talking about with anyone. This is just my own personal view. Number one is Jennifer McCabe, of course. No question. I think that would be anyone's answer. And, you know, who knows? There may be an opportunity to do that in another case.
The Aiden Carney case, maybe, yeah.
You know, I think a lot of people would say, you know, an obvious answer is somebody like, you know, Proctor. I mean, that's kind of like whatever. I think Buchanan is a much more interesting cross-examination than Proctor. But there's many other witnesses that I very much would have looked forward to cross-examining, but you know, whatever, didn't happen. So
Bono Buchanan, what kind of questions or do you think he should be asked?
Well, I mean, some of it is obvious. I mean, you work with Proctor, you're kind of attached to the hip on a lot of things. And the inverted video that's him. That's all you. You need to explain that, why you said what you said and why you did what you did. And I think that's an important thing, as well as a lot of the, you know, evidence that revealed itself on the lawn was kind of his call, if you will. Look, in a case like this, there's a lot of fascinating witnesses, some of whom may not be so readily apparent, but, you know, I don't even want to discuss that because I don't want to get into behind another guardrail.
Yeah. Let's go to this one. Can the defense file a motion to have readbacks for the jury, given there are nearly 100 witnesses?
I don't know how the Massachusetts procedure allows that or doesn't. I mean, we know from the first trial that there generally was no readback, which again strikes me as just culturally crazy. Excuse me. Case like this, I don't know how you don't have the ability to have that kind of readback, but you know, I don't know. That was unfortunate, though. I hope they don't have to do that again, but they may.
Question: how helpful would input from ER nurses of John O'Keefe be?
I think helpful. I mean, I think anyone with medical knowledge and dealing with, you know, triaging medical care and looking at injuries and seeing how people come into an ER. I mean, I think that would be very helpful.
Yeah, that would be huge. I think that's something that was kind of, you know, they have experts, you know, like Dr. Murray Russell, but I think like to that, you know, the person asked that question's point, you know, having some ER, you know, someone that has that kind of experience. If anybody listens to Nurse Kim's show, you know, she has experience in that. And I always like her feedback because it validates what, you know, a lot of us are seeing. But definitely, I think that'd be a great thing to see. I think that'd be a great way to go. And as Mark said on previous shows, you know, having more witnesses for the defense this time around, or even experts, would be a great approach. And I think this would definitely be a great, you know, having someone with that kind of experience, definitely go for it. Absolutely.
You saw, I mean, again, this is all publicly filed stuff.
Right.
With all the back and forth of the motions that are going on the last couple of weeks and witness lists and whatnot, there's a lot more proposed defense witnesses than there were expert witnesses than there were the first time.
I can't wait to see them all. It's going to be amazing. Apparently there's 12. That's what I've been told. If Bev allows Crosby in and goes over the moldings of Chloe's teeth, doesn't the Commonwealth have to prove it was Chloe? We don't trust a word Brennan says. What do you think?
Well, in the first instance, part of the problem is you've had these unsworn representations of what they've done with a dog that they claim is the same dog, Chloe. But you're being asked to take Brennan's word, or, pinky promise, Your Honor, it really is. That may work in the 4th grade, but in a courtroom, prove it. Let us know. And the problem is there's a pattern of no affidavits and what appear to be materially inaccurate statements. So I wouldn't assume anything. I wouldn't take their word. I'm not saying he's a liar, but I wouldn't take his word for it. She can't allow the moldings in. I mean, that's junk science. You don't even know. Hold on one second. You don't even know if those teeth are in the same condition as they were 3 years ago. Even if you accepted moldings, this is all ridiculous. I have no explanation for why Crosby is allowed in without any real judicial pushback when Russell wasn't. But even if he comes in, the moldings shouldn't. That's still, and you would just have to expect Crosby to be subject to a very vigorous cross-examination by someone who I'm assuming is really good in dealing with expert witnesses. I mean, really good.
Judge Jackson or Leslie, both of them are pretty good, I think.
Well, they're both really good, but I mean, you've seen someone in the last several weeks who really digs into expert stuff. So,
perfect.
Yeah,
it's funny about the teeth too, because dogs have teeth surgery. My dog recently just had a lot of teeth removed, and when they get older, it's common for owners to do that tooth surgery and take out 10 teeth. So, or
they chip, or they grind, or they move. I mean,
exactly. They come out, they break. Yeah.
You're talking about an incident that occurred in January of 2022, taking moldings that occurred, if they did this the way they said they did it, a couple of months ago, or almost 3 years later.
That's a huge concern. I'm glad you said that, Marcus. That's the point I was going to make, is that the teeth, they could change. They could, things can happen. They can, they can chip a tooth chewing on a dog bone over time. It's just not, it's just not inaccurate unless that mold was taken within a couple of days of when the incident happened. It's a lost cause.
But it's junk science anyway. I mean, it's not a very credit, even if the moldings were taken 2 days later. I mean, you're dealing with something that's not.
Not established.
Not established. Yeah.
Out there.
Remember, they have him. I mean, I think it was said in court. They look at Crosby as a rebuttal witness, so they're keeping him on ice for after Russell. But good luck, I guess.
Right.
I love Paper Squishy says, Mark, why did the defense ever talk about why Karen Reed never sounded intoxicated in her voicemails, only angry?
Well, I wasn't around the first time, and I'm not going to speculate what they know or would do or what was discussed this time. But to your point, in a general sense, there's no evidence that was introduced. I mean, again, this is just on what was at the trial. There's no evidence introduced that anybody saw her in a position they deemed to be unsteady on her feet, slurred speech, bloodshot eyes, anything like that. Everyone who was interviewed in all these bars said she appeared fine. There's plenty of evidence from people who observed that would cut against a finding of being blitzed out of your mind. I mean, that's just the trial evidence that was. As far as the voice messages, obviously if they don't sound like someone who's intoxicated, that's certainly a fair point to raise.
Definitely. Especially since all the witnesses seem to feel that way, that she didn't seem to be intoxicated.
Right.
Marcia has this comment. I wonder how many recorded audios does Chris Albert have from his D&E pizza device? And I'd add to Mr. Bederow, let's say it's 20. Just throw that number out. Or it could be 100, whatever number it is. Let's pretend it's 20. He's only got 20 recordings, let's say. Is that 20 crimes? Could he be charged 20 times? Or let's say it's 100. He could be charged 100 times, or would it be just one charge? How should law enforcement handle something like that?
Well, if somebody has, again, the felony crime relates to an intercepted audio communication. So in your hypothetical, that's 20 to 100 counts in theory.
And then are they felonies or misdemeanors? They're felony?
Those are felonies.
Wow.
There is a misdemeanor crime in Massachusetts to possess the device that does this with the intent to unlawfully record audio. That would be one count. The possession, you wouldn't get charged each time. So, but each intercepted communication, in theory, would be. Now, look, I'm not. I mean, would somebody literally get charged with 100 counts? Maybe not. But what was submitted was, we'd like to know what's going on here, and if crimes have been committed. Again, we expect the Canton police to be fair and equitable and charge everyone with equal zeal and vigor for these kinds of crimes. And, if these do exist, I don't know if they exist, but these are crimes against people's privacy. That should concern the local police department.
Is audio limited to just dialogue only? If someone like smoking a cigarette when they walk by and cough, for example, is that considered the interception of audio?
I don't know if that's what I'd call a communication. And that, no, I think that's a little different. I mean, the purpose of the statute, again, would relate to the interception of communication. And I'm not sure that coughing would, that's actually a question off the top of my head, would require more research. But what we're talking about and what the law is concerned about is just intercepting people, audio communicating. I mean, the law, Massachusetts, for whatever reason, always in that few states that just have to do things differently, right? I think there's about 10 or 11 states total that are what you would call all party or two-party states. Most parts of the country, this would not be illegal. That is true, but that's not the decision Massachusetts made.
Complaint from Meatball Morrissey's Sketty Stain that he bit his posture out laughing about the figure that lives in the attic. Well, your comments, he enjoyed those.
It's just an example. We were talking about trolls, and I'm just kind of surprised. I kind of feel sad for him that this continues as recently as today. He's just a nobody who rants and raves, and that's fine. It's his right. He has a strong opinion. Good for him. But I don't know why he likes to gratuitously engage with very juvenile, non-funny comments. I mean, if you're going to be that way, at least be funny.
I think he likes the abuse. I really do. I mean, out of all of them, he's better than Grant. He's better than KP. I like Kevin. I get a lot of laughter out of Kevin, even though he's not as bad as the other two. Let's just.
Well, I think it's kind of sadder with him, because I think he could have an intelligent dialogue if he chose to, rather than kind of like clown himself in the way that he does.
Yeah, it is sadder. It's true. Adam K says, thoughts on AJ's motion to dismiss presentation? I thought it was some top-notch lawyering.
Absolutely. No, it was excellent. The presentation, the preparation. That's a big part of the loss for me, is I very much wanted to try a case with him. I very much look forward to that. So, but yeah, no, top notch. Absolutely.
We've been trying to hit every super chat. It's crazy. There's been too many. I don't even think we've got half of them up. You guys are amazing tonight.
You have more super chats. You have more super chats tonight than some people that run shows on our opponent's side have viewers, Mike.
Yeah, for the whole year, probably. It's a good problem to have here, trying to read all the super chats. And all the questions have been great tonight. Very quality. Here's another one. What does Mark Bederow think about Auntie Bev making the defense stand up like children and take her scolding?
That bothered me a lot. That's another thing. More than 26 years, I've never seen. These are professionals. I know the point I think she was trying to make was that you're all responsible for what you all sign and this and that. But these are, four really high-level distinguished attorneys. And I didn't like it. I've never seen it. And I think if you're going to do something like that, you got to do it for both sides, or just not do it at all. I didn't like it. They're not children. They're professionals. If a mistake was made, if that's even the case, I don't think you need to have lawyers of that experience and skill level be called out publicly like that.
I love this one. Siobhan Man says, Mark, I miss you saying zombies.
Well, it's early.
Can you give us a few Bederowisms about the zombies or Chinatown Jake or
wow,
Fugazi?
Yeah, no, Fakakta, Fugazi. Yeah, it's listen, it is Chinatown. Norfolk County is I don't miss it. I was sitting there on the train home thinking about a lot of things, and I have to say, like, I'll have to come back obviously for other things, but to not have to deal with this, if this is how it's going to play out, it's not the worst thing in the world. I never thought that the crazy chaos of New York City and that whole messed up court system would actually feel so inviting and so comforting and so home. It was like couldn't wait to get back to like New York City courtrooms after that.
Another great question. Mr. Bederow, what do you think about the whole whistleblower? He's talking about Steve Scanlon, who tipped off Yannetti to what happened inside 34, now being on the Commonwealth's witness list. In my opinion, he has been threatened by BA.
I mean, I don't know why he'd be on the prosecution witness list. Obviously, as the prosecutor, I don't think you want to bring out evidence that he, allegedly spoke to the defense and planted the seed of something dastardly happened in the apartment. I mean, everybody knows the story. You've seen it online. You've read it in the news that this guy then kind of flipped his own story, wouldn't sign something, denied it. But why would the prosecution call him? That's bizarre to me. That appears to me to be making issues where if you're the prosecutor, you just assume not have it one way or the other. But I don't know. Doesn't make any sense to me.
A question about Fanning. Your thoughts on the story about Fanning and Colleen Crawford dissolving their business right after trial and the alleged tampered videos in a previous court case they were involved in. I don't know anything about that. I don't know if Mark does. There was another question that came in about Fanning and specifically about Brennan defending him so vigorously. What do you think about all that?
I don't get it. Look, if their position is that he did nothing to do with the jurors, that's appropriate to argue. If you don't think it somehow resulted in either juror interference or tampering or whatever you want to call it, depending on how severe it was, that's fine. Why you would queue up an argument that sounds like get ready to get the national anthem in the background playing and just start with this vigorous defense of him. It seems like a tough one to do. I mean, he did have, I know he was heavily involved in the Birchmore thing, which doesn't mean he did anything improper, but that's a tough case to be associated with. I don't know. Maybe some people thought he was just defending the state police and he's there to defend rather than argue. I mean, I don't really care one way or the other is what it comes down to. It was kind of weird to be that vigorous into saying, oh, he's, all-time great police officer. I don't know what the point of that was.
You want to say anything about any of that, Mazza?
I got no comment on that.
Okay. Here's a question. Did AJ ask Proctor times he met Karen Reed before his text?
I don't remember.
I don't recall that.
I don't know.
Might be a good point, though, to make.
Yeah. It would be, yeah.
Yeah. We've had so many super chats. I hope people aren't mad at me. I've really tried to get them all up and probably a record tonight. And you guys are overtime. We've been 2 hours and 22 minutes. You probably need to take a break and head out. Let's go with Mazza. Do you have any final thoughts tonight? Anything you want to share? Anything you want to promote? You have any big shows coming up? What's going on with Mazza Media?
Yeah, I'm going to be on a few shows this week. I'm going to be on the Glares fundraiser tomorrow, and I'm going to be with you on Brian's show on Thursday. I'm planning on the 27th doing a national standout preview with Deanna. I'm also going to turn that show into a massive multi-guest fundraiser show as well on Thursday the 27th. I'm working on it, sketching out the details right now. Other than that, I intend on having a couple spontaneous appearances on my own program and other programs in the next week. It's crunch time right now. This is kind of really, in my opinion, the last week or two. It's kind of like the preseason in sports, where the big season's about to begin again with this trial, and it's going to be a big time once again. And here we go. And I just ask everybody to just do what they can to contribute to Karen Reed any way they can. That includes her defense fund. Mods are typically posting that in the chat. Additionally, popcorn sales are going on right now. So Kelly Reed, Nick Rocco, a few others have popcorn links, especially on the Facebook group. Definitely visit that. You can buy popcorn, cookies, candy, all that great stuff. But right now, any way you can help Karen is great. Holding a sign, raising money for her, simply just raising awareness, even sharing links, anything you can do to assist her right now. This is it. I mean, here we are, round number 2, trial number 2, the bigger, badder sequel. Here it comes. We're ready for this one, and we have more of a group of supporters now going into this trial than we did last time, and I expect more people to start following the case as the second trial begins. But everybody's doing a great job. Continue to do that great job. And a lot of things are coming up soon. Aiden's going to be in court on the 18th as well. And then Karen Reed, has got a lot of appearances, I believe, coming up. Not sure what her appearance schedule is this week, but I believe
18th as well.
18th as well.
Both
Yeah.
of them are going to be in court Tuesday.
Right. So it's going to be big. Jury selection is going to be coming up around early April, I believe, right on the 1st. That should be interesting to see how that goes. But here we go, folks. Round number 2. And we ain't got no quit. Let's just continue to do what we do best and spread these links to these shows like the Mike show. Just hearing from Mark Bederow is really an invaluable opportunity. He's taught me a lot, and a lot of us a lot about this, and just hearing his feedback is awesome. I was very discouraged to originally lose him from being on shows, and was very excited to see him potentially be on the defense team. But now I'm kind of happy to have him back, but discouraged to not have him on the defense team. You just can't, you want him in both places at once. You want him on the shows and on the defense team. Yeah. It's always one or the other, but the bunk is back, and the bunk Bederow signals in the air. We got him back, and it's going to be interesting to see how this case unfolds, and just seeing what comes up with these shows and our daily. Probably a lot of shows we're going to be doing really soon. I'm looking forward to Mark Bederow's opinions on all of this. So just God bless everybody, and just pray for everybody's strength and poise and focus on this. And here we go, folks. We ain't got no quit.
Definitely follow Mazza Media on X and YouTube. He's got his YouTube. Make sure you follow him there. We got 2 more questions quickly for Bederow. Bederow, have you ever tried a murder case where the cause of death was not allowed? And here's a question too about, is there any chance of reversing the denial for appeal? Any way that there's any chance that you can get back in on the Karen Reed? They want to know.
So that's not my cross to bear. That's other issues for other people. Let's be realistic. They're starting trial in 2 weeks. So I would assume that issue was put to bed. Now, I wouldn't even think about that. As far as a murder case with a cause of death not being allowed, of course not. This is just another example of what are we doing here? Why a prosecutor who is accusing someone of committing a homicide, which is the legal word, right? Just literally another person causing another person's death, which is different than a suicide or accident. And, it's kind of a big deal in a murder case when the government's own medical examiner says, I can't determine. I mean, it's kind of a big thing. And only in Norfolk County, Massachusetts, would you see a prosecutor say, we shouldn't allow this to come in. The jury should not even know. Of course they should know. Of course the medical examiner should be able to explain why she came to that conclusion, what facts weighed against it. because the whole point for the defense is you don't know, because there are things that are not consistent with what the DA claims, that may not be consistent with a homicide, or could be consistent with an accident, or it's still America. They're allowed to put on a defense and challenge the evidence. And one of the things that you've seen throughout this case, certainly in the last few months, even more than the year before, is that they're in the business of preventing things as much as they are in trying to prove things. And it's fine that you want to attempt to prove Karen's guilt beyond a reasonable doubt, but it is still America. You have to give the defense an opportunity to challenge that. And they just, they keep telling you how many times, it's very important that we get a fair trial for the defense and this and that, but then they try to exclude all these witnesses that are clearly capable and competent, and in many instances, like Arca, for example, entirely exculpatory. So no, I've never seen anything like that.
Said I had 2 more questions, but I got a couple more. Had Mr. Bederow ever met Mr. Alessi before this case?
No, I hadn't, but our offices are like a block away, as it turns out. But I met Bob in Massachusetts recently, and I hope to see him in New York at some point. It didn't work out becoming brothers for life on this fiasco, but
you guys might run into each other, have lunch.
Absolutely.
Joe Flipperhead says, all right, Buck, let's get to what's important. Rank 1 to 4 Celtics biggest threat to make it out of the East. Pacers, Knicks, Cavs, or Bucks? He's going with the Knicks, Cavs, Bucks, Pacers. Is that all right?
The Knicks are not number 1. Clearly, it's the Cavs. Let's be honest. The Knicks don't play defense, and they're going to be too tired because they get work to death. They're good on paper, but no, it's going to be Cavs, Knicks, Pacers, Bucks.
Okay. I'm fine with that. I'll allow that. I agree with that. I'd say the Cavs are definitely. I think the Cavs are the only team that could legitimately beat the Celtics in the playoffs from the East Coast, at least. But not worried about anybody else too much.
Another question: Can Bev overturn a not guilty verdict to guilty?
If she was a judge in Nazi Germany, yes, but
not here.
Not
even a mass.
No. Well, this is real double jeopardy, right? Now we're getting into real issues of double jeopardy. No, if you are not guilty, you are not guilty. However, at least as it were in this crazy place where this case is being tried, if a lot of jurors think, or all the jurors think you were not guilty, but for whatever reason didn't convey that message properly, you can in fact be tried again, apparently.
Apparently, I missed some. There's been so many posts here tonight. I missed law offices of Andrew Myers in the chat was asking some good questions. Criminal defense attorney from Massachusetts. I wish I had seen those. That probably had some good questions.
Yeah.
We got a lot of good ones up there, though. Here's one more. I keep saying one more. Why do you think they want Morrissey on the stand? Any comment on that one, or is that one you can't comment on?
Well, the only comment I would say is I'm not going to speculate anything other than I didn't speculate a year ago when we talked about this, which is we talked about this. I mean, he made a statement where he said that Michael Proctor had no relationship with any of these people. That's not true. Now, they may not be, traveling vacation buddies, traveling the world, but he made a statement that there is no relationship with them, and that's not true. And the question for him would be, well, why'd you say that? Somebody must have told him. Was it Michael Proctor? Was it Tully? Was it whoever? So, I mean, realistically, is there going to be pushback from any judge to force the sitting district attorney to testify? Yeah, there will be. But I'm not going to speculate or opine beyond that reason. That's behind one of those guardrails for me.
It needs to stop.
It needs to stop.
There's simply no evidence.
Great. That was a good one, Mazza. Good imitation.
Yeah.
That was pretty good.
Thank you. Appreciate it. I'll be here all night. Comedy club after this.
Yes. So I guess, Bederow, do you have any final thoughts or do we already get them from you? What do you?
No, I mean, it's nice to see you guys. Long time.
Yeah.
Don't take this the wrong way. This was not my preference. Let me be very clear. I very much.
It wasn't our preference either. Yeah,
Right,
I
true,
wanted to
yeah.
see you in court. I want to watch you in court.
Right.
That was my
Yeah,
preference.
Mike already had other attorneys. He was auditioning on his show the past couple of weeks to replace you. You know, yell that upward, and you're back.
So,
Nobody can replace Bederow.
So I'll figure out how often going to do this. I'm not sure, to be honest. You gotta. There are things that will be off limits. So it is. It's not literally as stream of consciousness, just kind of rant and rave. There are things that have to. Yeah, no, that's right. And you have to be fair to the process, stay within the ethical constraints and all of those kinds of things. But it was important, certainly, to speak on what happened in terms of what was said about me. I have a right to correct the record about myself and respond to that. So I choose to do that. As far as talking about stuff that's in the public record, that's fine. Just it does impact your ability to share perhaps some thought processes and other things. But if people don't mind those restrictions, then, it's the kind of thing that I will eventually do again. But, didn't work out the way any of us necessarily thought. But here we are.
I didn't mind. I thought it was great. I would definitely have you back, obviously, as many times as we can have you. It's always awesome
Mike,
to have you on the show.
You've asked me questions. You've asked Mark questions. You've had questions asked to Mark. We haven't asked you the real question tonight. There's a lot of concern on X about you tonight, what you did. You roasted carrots with your chicken wings. A lot of people want an answer to that, an explanation live on this show right now, why you were roasting carrots with your chicken wings tonight. Explain this to us.
The glaze. When you have chicken, you want that soft carrot glaze. I love it. I just love my... Anytime I cook chicken, I got to throw some carrots in there. I can't help it.
Carrots to go with wings, you cook them?
Yeah, you could throw them in with the wings.
That's like when you're having regular chicken. You're supposed to
No. Especially my chicken. I cook it extra long.
The whole concept of celery and carrots with wings is it's cool. When you're eating hot wings, you take the celery and carrots that are hard and cold.
I sometimes do that, but I just like the soft carrots. I just love them. Okay. I do.
To each his own. To each his own.
And they give me crap that there's no seasoning on them. I do that for my girlfriend. I actually like the seasoning. I like to put but she doesn't. So yeah, I'm just gonna throw hot sauce on them.
On carrots?
Yeah. No, not the carrots. The wings.
I didn't think it was in light of your cooking carrots. I just figured, you're all in crazy.
No. On the wings. Yeah. They keep them separate. Yeah. Buddy. Important questions, Mazza.
That's right. I had to know. We had to know. There's a lot of talk on X about it. We got to know.
All right. Well, next time I have a lobster roll, they can talk about if I have mayo or butter.
That's right.
I like them both.
Yeah,
like them both.
Mayo.
Who was the show? Oh, I know. Auntie Deb and Brian from LTL. They don't do lobster. They don't do crustaceans. I'm like, are you kidding me?
I was not a fan of that conversation that they had. I'm very big on seafood. I love shrimp.
Oh, big time.
Clams, oysters, scallops.
Yeah.
Crab.
The clams? Are you kidding
lobster.
me? Fried clams? Fried clams? Are you kidding? You don't eat clams?
Fish.
Come on.
Yeah.
Oh.
The anti-seafood conversation was very much
this is like a Howie Carr show over here, talking about lobster rolls and fried clams.
Right.
You got mayonnaise. That is by far the single most repulsive food.
Oh, what is it?
Mayonnaise.
Mayonnaise? I love mayonnaise.
Thought of mayonnaise makes me want to throw up.
Oh boy. So you eat your lobster roll with butter, I'm guessing.
Yeah.
I don't eat lobster roll. I know that's like a big New thing. No, I'll eat lobster tail or a lobster.
Lobster tail's good.
Lobster tail's great.
I'm not interested in lobster roll, and I'm not interested in taking a lobster and ripping it to shreds. And I'll be honest with you, I'm not that much of an animal rights person, but I'm pretty animal rights. But I eat all kinds of meat. I'm not interested in going to the tank and saying, take that one and boil him and then.
I try not to think about that stuff.
I'd rather dump him in the ocean and say, crawl away.
Be free. You're free to go.
Man.
Yeah.
That's a problem with food, unfortunately. You start thinking about these poor animals.
Right.
Yeah, no, I don't step on bugs. I don't want to, but I will eat meat under the theory that it's already been taken care of. So what's the difference if I eat it or somebody else does?
Yeah.
Keep it at arm's length. Yeah, I open the door and let the bugs out. Yeah, I do that too. We had a mouse. I caught a mouse and I drove it a mile away to release it. I don't
kill those kind of animals.
That's what I normally would do. My girlfriend shamed me. Don't kill him. Don't kill him. He's a mammal.
The only thing we lantern flies, when we have the epidemic, you're supposed to just go crazy. So I don't know if you get those where you are. You get lantern flies in the summer, they're disgusting.
Yeah. What's up with those?
Trees that just multiply like by 1,000 in an hour, they're just disgusting.
Get rid of them.
Yeah.
Well, now that we've talked about animal rights and food and the Celtics, I think it's time to call it a night. I really appreciate you being here. Attorney Bederow, Mark Mazza. Follow Bederow Law on Twitter, or you can go to his website, bederowlaw.com. Thank you guys so much. It was great to have the 3Ms. I didn't mute myself. I beat that one. There was an over under 2 tonight. Didn't mute myself. Phenomenal. We had a perfect show, the 3 of us together. I hope we can do it again. Okay. And it felt good. Thank you guys so much for being here tonight.
Thank you. Thank you, Mike. Mark, good seeing you. Free Karen Reed.
And to the people in Ireland, happy St. Patrick's Day. You know who you are.
That's right.
Right. Happy St. Patrick's Day to everyone. Thank you guys so much for being here tonight.
Take care.
Okay.
All right. Bye-bye.
Take care, guys.
Good night.
Bye.
I know. We're the Young Jurks. That was phenomenal. That was so much fun. Great to do that again. I just I tried to post every super chat up tonight, and I tried to read as many, but I don't think it was a record for viewers. Pretty close, but I think it might have been a record for super chats. Everyone wanted to get their question in. I'm sorry I didn't see the other chat. I try to get questions from there too, but there were just so many super chats tonight. I really appreciate you all watching. I haven't even looked at the Venmo yet. I have a feeling I did see some Venmos come in tonight. I want to thank our Venmo people. Yes, there were a couple of Venmos. Alice sent 50 for the 3M. She said, thank you so much, Alice. That's very generous. Alice W., thank you so much. Barry Lewis, we know Barry. Barry said, happy birthday, Meredith. Hope you are having a very good Sunday. I hope that was meant for us, but happy birthday definitely to Meredith. Meredith is doing a big fundraiser. She's got something going on with Auntie Deb on a show. She's going to do a big fundraiser for Karen Reed. Definitely check that out. Happy birthday, Meredith from Barry. You wanted us to read that one. Tracy DJ, I'm going to call her. She says, great job, 3M night. She said $15. Thank you so much, Tracy. Barbara M, she also sent $10 tonight on Venmo. Thank you so much, Barbara M. And I'm going to check the Cash App, see if I'm missing anything there. Yes. Holly sent $10. She said she's so happy to see Bederow back in your chat. Thank you so much, Holly. Yeah, we were very excited tonight. Elaine sent $100 on the Cash App. Wow. She said, thanks for all you do. Love seeing the 3Ms. Thank you so much, Elaine B. Wow, you're awesome. Thank you so much. Casey sent $5. She said, for a great show. Love having the 3Ms back together. Love. Thank you so much, Casey. It was love tonight. This was it was amazing. Gary from Canton sent $10 last night. Leave for the review of the Canton Select Board Candidate Forum the other night. That was great. Did that yesterday afternoon. Thank you so much, Gary. Really appreciate that. You guys are so generous. I really appreciate all the support. I thank you for all the super chats. I really tried tonight. There was an overwhelming number. His name is Bederow. That is true. Thank you, OnlyFan. Thank you, Michelle. Thank you, Donna. I'm going to try to just thank everyone if I can real quickly. Chief LOL Rafferty, Jish 7881. Thank you, Diane, Donna Rash. Thank you, JC, the Music Man. Thank you, Only Dog Design. Thank you, Sherry D. I also want to mention Tiffany, Uncle Frank. If you guys could send her some love right now. She's having a surgery this week, I think tomorrow. She's a big supporter of ours. She sent me some donations to buy a jacket that hoping to come in soon. That will be the same brand that the patriarch of the Reed family wears, Bill Reed. But send some love and support to Tiffany, Uncle Frank, if you can, this week. She's having a surgery. We're hoping it goes well for her. Thank you, LTL Media. I'm going to send everyone to LTL Media right now as we close out the show. He's got a show tonight. He's going to be going over Trooper Paul coverage for Paul testimony, excuse me. So check that out next. Akita Leva, thank you. Thank you, FKR 2024. Thank you, Siobhan. Thank you, Tristan Morris. Thank you, Magnolia. And Rock Hard. Thank you, Elf. Thank you, No Shrinking Violet. I think I'm only like halfway through here. Jenny, Amy Z. Thank you, Siobhan again. Dirty Hanky, Akita Lover, Laurie. Thank you so much, Laurie Life. 360 for the win. Thank you, Bev's Cognitive Issues. Thank you, John. Thank you, Serenity RPH. Trying to get them all up. This is a lot. Thank you, Lamasus. I gotta know. Thank you. Thank you, Mallory. I know you didn't like my wings. Thank you, unapologetically authentic. And Bonnie and Joanna, excuse me. Kelly, thank you. Kelly Steffi, thank you. Thank you, Laurie Donley, hypnotherapist. Thank you, Marsha. Thank you. I love paper squishies. Thank you, Meatballs, Morrissey, Sketty Stain. That's a good one. Adam K, Erica Clark, thank you. Or Eric Clark, excuse me. Eric Clark, thank you. Fancy Fact Finder, thank you. Thank you, Mr. Mox Underbelly. And Concepta McNamara. Let me say that again. Concepta McNamara. Thank you, Danielle. And A and Edward. I don't even think I'm going to have time to go through all these. Schmo. Thank you, Annie. Thank you, Cynthia, Lola, Douglas. I think I read most of these tonight. I'm trying to get them all. How's Long, Rhonda Hinckley. Thank you, Motions and CPA. Thank you, Stephanie. Amazing. Thank you, Cape Cod Cred. 2:27 a.m. search happened. Thank you. Thank you, NDF. Thank you, Rosemary. Thank you, Jody 617. Trying to get them all up. This is wild. Thank you, Joe Flipahead. I don't think I'm gonna have time. I gotta go walk Fergus, unfortunately. Thank you, D. Thank you, PU. Thank you, Edward. This is wild. Pro Gamer. This is like the best thing you ever want to happen. You have too many super chats to read. Mama She 13. These are first world problems over here at the Young Jurks. We have so many super chats. Happy Warrior. I am such a medical doctor parachuting in. Thank you. Thank you, Hope. Thank you, Lola, the good dog. Thank you, Hope, again. And Romy, she's always great. Thank you, Romy. Thank you, Kathy S. Thank you, Danielle. Proctored and doctored, thank you. I hope no one complains that I didn't put their super chat. Do you see how many there are tonight? I'm like halfway through them. Abacus Flinch, thank you. Thank you, Emily. Anne Marie, thank you. Thank you, Lizard and Kevin and Lizzie's room. Quello, Jean, Mr. Monk's understudy again, thank you. Thank you again, Joe Flip ahead. Emily, thank you. Brit Happens, thank you. Check out Brit Happens. She's great. Got a good show. Thank you, Badass Bish. Thank you, J Beans. Thank you, Ashley. Thank you, Jennifer. Getting wild. 5,000, you're watching me read names. Thank you, Lizzie. Thank you, Edward. Thank you, Done for Real. I think I gotta go. Just want to thank everyone, all the new memberships tonight too. And if you haven't subscribed, please subscribe. Please follow Mazza Media. Make sure you follow Mazza Media. Make sure you're following Bederow Law on Twitter and X. And make sure you're following the Young Jurks. Make sure you're following the Young Jurks on Twitter and Facebook and YouTube, especially. Make sure you subscribe and like on your way out. I want to thank everyone who's been watching tonight. And sharing and excited as much as Mazza and myself and Bederow were tonight. You guys were really excited. I want to thank our moderators, especially Sarah and Shock and Hara, who's here right now, Jeno, Stephanie, MJ. I want to thank the 4 ladies that we have moderating our chat. They are the best, and Scott McGinnis. We have the best mod team. I'm so thankful for them. Yeah, thank you, mods. I love our mod team. Yeah, they kick ass. Thank you, Lauren. Lauren TZY, good to see you here. I'm going to check out tomorrow night. We have a new attorney here at 6 p.m. We're rescheduled. We couldn't do the show last week. So make sure you check that out tomorrow night, 6 p.m. Hit the notification button. We'll also have a show on Tuesday night with the state auditor of Massachusetts, Diana DiZoglio, coming back on the show. I think she may have something to say about Morrissey this time, too. So come check that out. That's going to be fun on Tuesday night. And also, obviously, Karen Reed is in court and Turtle Boy Aiden Carney is in court on Tuesday. There's a lot happening this week. We'll be covering it all. Keep checking in. If you didn't get to see, watch the forum that we just replayed last night with Susan Harrington and John Connolly. That was great. All right, I'm out of here. We're going to go watch LTL Media together. Let's go check him out. And in the chat, I'll see you all over there. Have a great night, everyone. Thank you so much for all the super chats that I couldn't even put on the screen. There were so many of them. The Goodmans. I'm just a girl in the world. Lindsay M. AKA the Cat Lady. Have a great night, everyone. We'll see you tomorrow night.